when ultimately Article 47 came, it used the word intoxicating drinks. So intoxicating liquor has been used in that sense only, my lords. And Mr. Sirvai's quote has been already pointed out to my lords. In that, so I am not repeating that. That is in paragraph 38 of my written submission, my lords. Now, my lords, directive principles, all the fields, my lords, have paragraph 35 for a moment, my lords. The fields enumerated in the directive principles find place by and large in one or the other lists of the 7 schedule, my lords. Article 47, I have given Appendix 2, my lords, which this is at page 41 of the written submissions, my lords. This gives the comparison of which are articles and which is the legislative entry. But
ఎంత బిజీగా ఉన్నా
para 35 read with appendix 2, right? That is at page 41, PDF page 41. My lords, the only thing one I would like to point out, the most important entry has been missed out in this appendix, my lords, which my lords may add at page 44, serial number 11. Entry 8 of list 2 has to be added in that, my lords. This has been missed out in the comparative chart appendix 2, my lords. Now coming back to
yes.
my lords, if entry 8 talks about intoxicating liquor, my lords. If alcoholic liquor has to be added in that, it has to take color from the other entries in the same list, my lords. And I am saying so because when the Law Commission report recommended that all alcohol be included in the state list, that was not accepted by the Parliament, and they restricted only potable alcohol, and non-potable alcohol was under the IDR, my lords. Therefore, they were very much conscious of the fact that state has only the power to the extent of potable alcohol and no further.
Yes. What is the next point?
My lords, next point is power to legislate on 245, 246.
So we'll take it as a second point.
Second point is the scope of 245, 246 and 254. This is at page 6 of my written submissions, my lords. Paragraph 4.
Tell us that again, please.
Paragraph 4, I have summarized 240. My lords may have 245 and 246 for a moment. Then I come to that, my lords.
What para?
Page? My lords, Constitution, my lords may have it.
Okay.
Article 245, 246.
So why don't you tell us what's the point that you're making?
246, 1 and 2 starts with notwithstanding, that is non-obstante clause, and clause 3 of Article 246. Subject to, my lords.
That's just
and this is the enabling provision to make laws. My lords, when we go to Article 254 for the repugnancy, it talks about laws made by the Parliament. So once the law has been made by the Parliament, then the test of repugnancy will take place vis-a-vis the state law, my lords. And if a law, Parliament has made the law, then to that extent, the state will be denuded of its power.
45(3), you are right, because
Right.
we have discussed it. Yeah.
Right, my lords.
What is the next point?
My lords, now here, once the field is occupied, my lords may have 162, Article 162 for a moment.
What's the point you're making?
My
That the
lords,
executive power of the state is
even-
coextensive with the
No,
legislative.
my lords, proviso to 162 is very important.
Yes.
May I read, my lords? Provided that in any matter with respect to which the legislature of a state and parliament have power to make laws, the executive power of the state shall be subject to and limited by the executive power expressly conferred by this constitution or by any law made by parliament upon the union or authorities thereof. In my humble submission, my lords, under the IDR Act, specific executive powers have been conferred on the central government, my lords. Like in 18G, it can notify, then there are other provisions. So once that power is there, the state is denuded of all its power, including legislative and executive power, to make laws in respect of IDR Act, my lords. The issues in this regard, my lords, there is one constitution-based decision, 2016, volume 7, SCC 1.
Where is it? Where do we find it in the compilation?
It is not in the, because it was
All right,
last
what does it
I
say?
have given 2016, 7 SCC, page 1,
In Share
paragraph-
Yes.
Union of India versus, my lords, para 140. My lords may have it. I won't read the entire discussion, my lords. Para 140.
What is the point that you are stating?
My lords, the executive power under 162. Because my submission is the act has been enacted under the legislative power and the executive powers under the act have been conferred to the central government, my lords. Therefore, the state is denuded of its power even in respect of executive matters, my lords. My lords may have para 140 at page 117. Thirdly, my lords got it? Thirdly, a situation may arise where the authority to bring about a law may be available both to the union as well as the state, that the law made by the parliament may invest the executive power with the centre, while the state may also enjoy such executive power by virtue of a law which the state legislature was also competent to make. In these situations, the ratio laid down by this court in the decision in so and so will have to be applied and ascertained which of the two, namely either the state or the union, would gain primacy to pass any order of remission, etc. In this context, it will be relevant to note the proviso to Article 162 of the Constitution, which reads as under. After the quotation, my lords, if the proviso applies to a case, the executive power of the state should yield to the executive power of the centre expressly conferred by the Constitution or by any law made by Parliament upon the union or its authorities. Therefore, in my humble submission, the entire power, may be it legislative or executive, that has been taken away from the state by enacting IDR Act, my lords. The other relevant paragraph is 173.11. 173.11, where they have summarized, my lords. I'm not reading that, but this is the main.
But see, Article 73 proviso, huh?
Yes, my lords.
The proviso to Article 73.
73. It's quoted, my lords, in this. 73. Yes, my lords. 73 proviso. Provided that the executive power referred to in subclause A shall not, save as expressly provided in the Constitution or in any law made by Parliament, extend in any state to matters with respect to which the legislature of the state has also power to make laws, subject to the laws made by the Parliament.
So, if it's a field in the concurrent list,
Yes.
then even if it is a union law,
Yes, my
the
lord.
state has the power, executive power, unless that law provides otherwise,
Provides.
expressly.
Expressly. And in my humble submission, the entire provisions, if my lord reads the entire act, the entire executive power has been vested in the central legislation. My lords may have sections 25 and 26 of the IDR Act for a moment.
Mr.
The other
Agarwal,
provisions?
this also we must also take into account
Yes, my lord.
what is provided in the IDR Act
Yes, my lord.
and what is specifically excluded out of the
Yes,
IDR Act.
my
Now,
lord.
when it says fermentation, and we have
Yes.
gone through it many times,
Yes.
fermentation industries other than potable
Yes, my
alcohol.
lord. Yes.
So we must understand. I mean, that potable alcohol part
Yes.
would always remain with
Yes,
the states.
I'm not on that. I'm not on that.
Right.
Potable alcohol is within the domain of the state legislature. I'm
Saying
restricting
that in the context of denatured spirit,
non-potable, my lords.
Denatured,
Denatured is one
let's-
of the species of non-potable, my lords.
let's use the expression denatured spirit.
Yes, my lords.
In case of denatured spirit,
It is with the union.
The Union of India.
Yes.
That's the
Yes.
proposition
Yes.
that
Yes.
you are
My lord,
expounding.
I'm not restricting to denatured because non-potable
This
is
is
the
where we-
non-potable is the correct phrase, my lord, because they've excluded potable. Potable means safe for drinking. The literal meaning of potable is safe for drinking. I don't have to go to any dictionary for that, my lords.
So are you saying that potable can be equated with the subject in entry 8,
8.
intoxicating?
Intoxicating liquor.
Intoxicating liquor is.
And that is why when it was recommended, Law Commission report recommended to include entire alcohol in the state list, entire alcohol outside the IDR Act, that was rejected by the Parliament.
Because intoxicating liquor within the meaning of entry 8 is for drinking
Beverage.
purposes. It's a beverage for-
purpose. I am obliged, my lord. So my lords may now have sections 25 and 26.
Liquor for industrial.
Which is
From section 25 and
section
26.
25 is the delegation of powers. My lords, the center can delegate the power, and to that extent, my lords may have section 26 for a moment.
And directions.
Directions, and directions have been issued in the instant case, my lords, post 2016 amendment. My lords may have volume 4A, PDF page 489. In fact, I have quoted the relevant portion at page 48. Page 48, paragraph 26. Page 46. 60. Para 48, page 24, my lords. Have my lords got it? Volume 4A, page 489. And the relevant portion has been quoted in my written submissions at page 26, para 48. Page, PDF page 26, para 48. My lords, I was at para 48 of my written submissions at page 26, where a specific direction post 2016 amendment has been issued. Relevant portion I have quoted, my lords. In a present circumstances, my lords, may I read the direction itself? That would be sufficient. Now, all issues pertaining to fermentation industries other than potable alcohol, such as control over its licensing and regulation of the manufacture, storage, acquisition, possession, use, consumption, transportation, trade and commerce, supply, distribution, and its movement, including intra-state and interstate movement thereof, and the grant or issue of such license, permit, or other documents, and charging stroke levying of fees, if any, etc., shall be under the exclusive control of the Government of India. Further, any such control by state governments over the field indicated above, including on intra-state movement of industrial alcohol, that is other than potable alcohol, or alcohol for EBP program, stands repugnant to the amendment issued by the central government, wide amendment dated 14/5/2016. So all the powers with regard to non-potable alcohol, directions have been issued in exercise of the powers under 26, my lords. And many of the states, including the state of Maharashtra and Punjab, have accepted this. I have annexed those in volume 4E. Minutes of meeting and the acceptance by various states, including Maharashtra, Punjab, and various other
That's
states.
all right. Whether they accept it or not, we have to go by the constitution.
Yes, ma'am. So
This
this
What is the next point? We'll hurry along now.
now, my lords, 18G is one of those executive powers, my lord may note, because the entire gamut of their argument is
Your third point was section 25 and 26, or third point was article 162.
162.
Okay, just a second.
In 162, my lords may note, section 18G was specific that it is with the central government.
18D.
18G, G for
Yeah,
Goa.
yeah, that we have seen.
Yes.
Then your fourth point was section 25 and 26 of IDR Act.
IDR Act.
What is the next point?
My lords, next point is, my lords, we have the first schedule for a moment, my lords, of the IDR Act.
What is
My lords,
formulated?
the product which are mentioned are in the exclusive domain of the central government, my lords. My lords, may have first schedule for a moment.
But there's no doubt about this.
My lord,
exclusive domain.
My lords, may give me 2 minutes. I'll explain what I have it in mind, my lords.
Just formulate the point and then tell us.
My lords, the first schedule opens with any industry engaged in the manufacture or production of any of the articles mentioned under each of the following heading or subheadings, namely. So any of the articles which are being manufactured will fall within the schedule industry, and 26 says fermentation industry other than potable alcohol, and the products are alcohol and other products of fermentation industry. So it is specific that non-potable alcohol is in the exclusive domain of the central government, my lords, union. Because the product as such has to be seen, not its ultimate use, or it can be diverted, or it can be used. The product which is being manufactured is non-potable alcohol, and it has to be seen as such, not its potentiality, my lords. Potential use is not the key test over here, my lords. It is the product which is being manufactured is the relevant factor.
Or potential misuse.
Use of, just a passing thought,
Yes,
use of beer
yes, my lords.
for washing your hair,
Yes, my
will it be misuse or use?
My lords, it depends. If it is healthy, then it will be used. Because while washing, one can also have the beer as such, my lords. So it's both use and misuse.
Using beer shampoo is not intoxicating, I have.
It's not.
So there will be use and abuse also.
My lords,
See, while making, they sort of, they sort of siphon off the intoxicating part of the product and was washed away.
well, as my learned colleague says, using beer for shampoo will not make it a beer as such, because then only beer is not there, something else added to the beer for using as a shampoo, my lords. It would not be, my lords, on the
So
list.
that this is the next products in the first schedule are in the exclusive domain of the central government.
Yes,
And
ma'am.
the opening words, any industry engaged in the manufacture or production of any article.
Article, because there are certain entries, my lords, where all the articles which are capable of being manufactured by the scheduled industry is not covered. Yes, my lords. My lords, may give me a moment, ma'am. My lords, the legislative history of IDR Act, because industrial alcohol has been loosely used, that was the argument. Industrial alcohol was in the original act, my lords, of 1951. My lords, I have given the compilation of the legislative history of IDR Act in volume 4F.
All right.
4F, my lords.
What else?
My lords, industrial alcohol, in power in industrial alcohol was in entry 24 at page 31 of the volume 4F.
All right, just 1 second. Let's go to that.
In fact, I have summarized in the list of dates in the opening page itself of 4F, my lords.
Volume 4F. Page.
Page 1 itself, my lords may have it, volume 4F. And the supporting documents are there, my lords. My lords, on 26th March 1949, when the bill was introduced, the draft entry was 18 in the first schedule, power in industrial alcohol. Then the 49 amendment bill came and the entry was 24, but it remained as power in industrial alcohol.
Mr. Agarwal, you're making an important point. Just let's quickly run through it. So 51.
51,
The bill was power and industrial
alcohol. Then an amendment was made.
Before the amendment,
Yes, ma'am.
came the Act in 1951,
1951.
where it was item 23, power and industrial
Yes,
alcohol.
my lords, at page 31.
Then came the
1956 bill, my lords. This is very important. 1956 bill, page 93 at 95.
and then entry
Entry 25 at page 98.
became fermentation industry.
No, my lords, fermentation industry, and then 1 and 2,
Ah,
alcohol
right.
dash industrial and power. My lords may note, this was in the bill. When it came to the Lok Sabha in debates, my lords, PDF page 152. Page 152. Right hand side, my lords, right hand side column, about 10 lines from the bottom, my lords. Page 8. Have my lords got it? Page 8. Right hand side column of the Lok Sabha. 2. These were the amendments which were moved. PDF page 152. Sir, I beg to move 2, page 8, 2I, II. Line 12, omit industrial and power. So the amendment was made to remove industrial and power, and the reason was this is intended to remove a printing error. My lords, page 152, right hand side towards the bottom, it says paragraph 2, 2I, II. In line 12, my lords, it starts, sir, I beg to move.
No,
Something,
No, my lords, page 152 of the PDF, my lords. PDF,
no, it starts with on the right hand side, Industries, Development and
Regulation Act. Yes, my lords.
Is that
Then
what you're
towards the
saying?
bottom, towards the
Towards the
bottom.
Bottom continues in Hindi.
Yes. Then thereafter,
So 154 we go to. 52.
2 and II.
Just a minute.
PDF page 152. Printed page 149. Printed page 149 towards the right hand, about 8 lines from the bottom, my lords.
Sorry.
II, line 12, omit
Industrial and power.
oh, 149.
Or omit.
industrial and power. These are removed, and the reason for removal is this is intended to remove a printing error.
What is the printing error?
That was industrial and power had to be removed, my lords. Only alcohol as a whole was to be there. The bill said alcohol dash industrial and power. So industrial and power has been removed and the entire alcohol was included, and that was the position till the 2016 amendment. This is how alcohol was introduced. So this alcohol meant both potable and non-potable.
2016 is only alcohol.
In the original act, it was entry 23.
Yes, my lords.
Which says power and industrial
Industrial
alcohol.
alcohol.
1 second.
Yes.
Right? Then comes the 1956 amendment.
Meant,
It entry 26,
yes.
which is fermentation industries dash alcohol.
Fermentation industries, then 1 and 2.
No,
Yes,
we've seen
alcohol.
it. That is alcohol.
Alcohol.
And then 2016, it is entry 26 is substituted as fermentation industries other than potable.
Other than potable alcohol. So now it is restricted, and this is a retrospective amendment from the date of the act itself. So my learned friend Mr. Datar said the amendment came in 56. So how can it be retrospective since 1953? So this is the legislative history and how it has been made retrospective from 1953.
Now, just 1 second, so that later on when we are dictating, we don't have to start hunting pages.
Yes.
1951.
Yes.
The original act.
Yes.
What is the PDF page in volume 4F? Just tell us.
4F. 4F. It is page 1 at 31.
Page
Page 36 at 42. Volume 4F, page 36, PDF page 36 at page 42.
All right. Then the 1956 amendment, we'll just look at it,
Yes.
you know, in a
Yes.
fraction of a moment.
Yes.
1956 amendment, where
Bill.
entry 56 comes. Don't forget the bill now.
Yes,
We
ma'am.
didn't even
Yes.
confuse ourselves with
Yes,
the bill.
it came from 1st March 1957.
What is the PDF page?
It is not, Act is not here, my lords. This.
All right, it's not there.
Yeah, okay.
Fermentation industries, bracket
Al-
1, alcohol at the bottom.
Alcohol.
And then 2056,
2016.
2016, we of course have it,
Yes.
but give it to us again.
Yes, 2016 amendment is 4B, page 576.
Volume
4B, B for Bombay,
B for Mumbai.
B for Bangalore, Bangalore,
All right.
M for
volume
Mumbai.
4B,
B.
page.
Page 576.
All right. ठीक है.
So, my lords, in my humble submission, potable alcohol as such is covered by, and the product which is manufactured from that industry has to be a non-potable alcohol. So, its use or misuse, my lords, will not determine the legislative power, my lords. My lords, I have given the, my lords, IDR Act is in in exercise of two legislative fields, my lords. One is entry 51 list, 52 list 1, and the second is entry 33A list 3, my lords. Entry.
What's the next point now?
My lords, I am on that only. My lords, IDR Act is a complete code. Declaration is under section 2, which is deriving power from entry 52 list 1. Rest of the provisions of the Act derive their power from entry 33 list 3 of the Constitution, my lords. My lords, entry 33A, 33 says trade and commerce, supply, distribution, and production.
What's the point now?
My lord, so all these points have been covered. I am only pointing out Appendix 1, which I have in my written submissions, my lords.
Appendix 1 to your written submissions?
Written submissions.
What does it say?
I have tabulated which field is covered by which provision, my lords.
Which?
Which field under entry 33 is covered under which provision, my lords. PDF page 40.
Where will we get Appendix 1 page?
In my written submissions at page 40.
Which is
PDF
volume
page 40.
2E.
2E.
Let's go to that.
Page 40, my lords. So all the fields, legislative field under 33A is covered, my lords. I'm not going through the act. मैं बोल रही हूँ Fine.
Now
Only-
what remains, Mr.
Only
Agarwal?
2 points, only 2 points.
Only 2
rebuttable.
points. Thank you.
My lords, one is stay decisis, my lords. It has held the field from 1989, my lords.
Synthetics.
Synthetics. And the amendment has been effected in line with that, my lords.
1 second.
Synthetic is
1989 was the judgment,
And reported it.
reported in 1990.
All right. And last point.
My lords, and I have given the list of judgments, Appendix 4, which have followed synthetics, my lords.
1 second. Let's make a note of that.
My lord, this is a classic case.
Appendix 4 page.
Page, I'll give my lords Appendix 4.
Page 50.
Page. My lord, this is a classic case where the decision of this honorable court has been accepted by the government. Parliament has enacted a law in line with the decision of this honorable court. And the executive has also followed it, my lords. Apart from the various courts which have relied upon synthetics since the last 34 years.
Not classic case, rare case.
Rare case. This is the only case which I could find where the government has accepted the
All
judgment.
right. What last point?
Yes. My lord, there were two arguments made by the other side. One by Mr. Jaideep Gupta for State of Bengal, that would be an administrative chaos. My lord, administrative chaos cannot be a ground to justify whether the legislative competence, my lords. There is a sentence in the judgment of this honorable court in B. Prabhakar Rao, my lords. When you have stirred the hornet's nest, you should be ready to kill this thing. Hmm? My lords, if my lords want, I can give the citation. I'm not reading that, my lords. That is 1985 Supplement SCC 432, para 20 at 462.
Supplementary 4 SCC.
Supplementary SCC 432. At that time, there was only one supplementary volume.
And para?
Para 20 at 462, quoting Lord Denning, my lords. And then this was later relied on 2014 4 SCC 720, para 70.
2014 4 SCC.
CC 720, para 70.
The earlier judgment, is it in the compilation?
No, it's not. It's
Second
not.
one also is not.
I'll give.
All right. Thank you, Mr.
My
Agarwal.
lords, one more thing. My lords, Mr. Balbir Singh, while appearing for Maharashtra, said we are following BIS standards of denaturance, my lords. My client used BIS standard and is being prosecuted because they say it is our standards which have to be taken and not BIS standard, my lords.
Thank you, Mr.
Deep your pleasure.
You are satisfied now that you've given me a full hearing.
My lord,
Thank you.
the only thing is,
I
my lord,
must compliment you. You are also very precise and absolutely on the point. So we
my
appreciate
lord,
Thank
I
you.
may be permitted to file a 2-page.
No, now don't file 2 pages. Now you've filed so many pages before.
Deeply obliged.
Yes, Mr. Bhandari.
Well, I'm only going to take 5 to 7 minutes. I filed a very short note, which is at volume 2H. So, my other submission can be ignored because it will be repetitive to what others have filed. So, I filed now 2H, which is a very short note. Volume 2H.
Volume
2H.
In fact, my lord, my lord, for alcohol, one I had already told my lord the Chief Justice about Mr. Nariman, my lord, but the most oft-quoted couplet in Urdu about alcohol is that, Zahid means, the cleric means, And it said, मैं जाहिद शराब पीने थे मस्जिद में बैठकर या वो जगह बता दे जहां पर खुदा ना हो.
Beautiful.
Look, my first argument is that the decision of Bombay High Court in Balsara is the right decision and gives the correct interpretation to the term intoxicating liquor. And that's para A of my note. Bombay High Court reasons this in about 4 or 5 or 6 lines, and I've quoted that exact paragraph. If my lords looks, my lords, it says in the first instance, liquor ordinarily means a strong drink as opposed to a soft drink, but it must in any event be a beverage which is ordinarily drunk. Now, the other side wants to argue that the term liquor comes from liqueur, and therefore please extend it to also include liquids. But if one looks at the Constitution itself, the Constitution in entry 53 list 1 uses the word liquids. So liquor and liquids cannot be interchanged.
Where does the Constitution use? Yes, of course.
Yes. At entry 53 list 1, liquids is a term used in a non-consumption manner. So therefore, to extend liquor to mean liquids, the answer is in the Constitution itself, because Constitution uses the word liquids when it wants to use the word liquids. That's at entry 53 list 1. So as far as liquor's definition given in Balsara's High Court judgment, meaning a strong drink, that's the correct one. Then second reason why Balsara High Court states that it's for human consumption is because then it goes on to define what is the meaning of the term intoxication. And it says, very interestingly, in the second place, the use of the word intoxicating in item number 31 in contradistinction to the use of the word alcoholic in item number 40A as qualifying the word liquor is very significant. We may also point out that in the white paper, item 26, which corresponded to entry 31, used the word alcoholic liquors, which have in Government of India Act been changed into intoxicating liquors. Therefore, it is apparent that from the class of alcoholic drinks, non-intoxicating drinks are excluded by this entry. Thirdly, medicinal and toilet preparations containing alcohol which are found in entry 46 are neither liquor nor intoxicating, and therefore they are obviously excluded from the scope of item number 31. So, my lords, there it reaches the conclusion why intoxicating should be something for human consumption. My lords, then if one steps back and looks at Article 47, why is entry 8 worded in the way it is worded? If one looks at entry 25, one will see that when they wanted to do gas and gas works, they said gas and gas works full stop. But when they drafted entry 8, they gave it with full splendor. That is to say production, manufacture, supply. That is because if one steps back and looks what the state is vested with, the state is vested with every power to achieve and fulfill what Article 47 Directive Principle mandates it to do. Therefore, entry 8 had all these words to ensure that if state wants to fulfill its objective under 47, it can do that and has enough powers there. That's why entry 6 also public sanitation is with the state. And more importantly, entry 51 list 2 gives state full power to levy excise duty on potable alcohol. So this all flows from 47, because to achieve the purpose in 47, entry 6 public health and sanitation, entry 51 tax on excise duty, and lastly but not least, entry 8 list 2, which says that is to say production, manufacture, supply, everything is vested as far as potable alcohol is concerned with the state, so that it can fulfill its objectives under Article 47. So my humble submission is that the definition of intoxicating liquors, one can see what it means by looking at the Constitution itself. Then, my lords, I cite after that, there was an argument made that if you look at the Indian Government Act of 1935 and you look at the local acts in and around that period, then intoxicating liquor, especially liquor, could mean liquids also. But my lords, the only point I'm making here is that even under the Indian Government Act, there was a Power Alcohol Act of 1948, which synthetics too was looked at, and therefore so from those days itself, industrial alcohol is within the center's control. Now, Millards, para 2 of my note, Millards, I have actually set out where all the term intoxicating is used in the Constitution. It's very interesting. Article 47, then there is Article 36629AF, and then there is Schedule 7, Entry 8. All these three places where the term intoxicating is used is in connotation for human consumption. there is one more place which my note left out, my lords, which is Schedule 6 of Entry 3B, which deals with special laws for Bodo land. There also it's for human consumption.
Just 1 second.
But that's para 2 of my note.
In Article 47, Article 366,
29 AF.
and Entry 8,
Yes.
and which was the final
And
one?
then, my lords, one final which is left out is Schedule 6, Entry 3B. The Constitution. All, my lords, are in the context of something which can be consumed. So intoxicating has never been used in the Constitution in the context cannot be consumed or not fit for human consumption. So, my lords, that's as far as intoxicating liquor is concerned. Now, my lords, the second point I want to make is, my lords, I feel, my lords, the case of Tilak Ram was dealt with. What was not dealt with in reply, I suppose, was the Calcutta Gas Company case, which follows Tilak Ram. Now, Calcutta Gas Company case, my lords, I don't need to go as far as saying, please overrule these judgments. Tikaram, I'm sorry. Calcutta Gas Company case, I don't need to go as far to say, please overrule Calcutta Gas Company to make me reach where I want to reach. According to me, if one looks at Calcutta Gas Company case and looks at the reasoning of Calcutta Gas Company case, it supports me because the way they dealt with the analysis, if that same analysis is applied, then Entry 8 would exclude industrial alcohol. And I've cited a very interesting paragraph from Calcutta Gas, which was the key paragraph, where Calcutta Gas was trying to look at Entry 25, which said gas and gas.
That para 9 that you quoted page
Yes,
6?
I've quoted, yes. From para 6, I've quoted it, and I've quoted para 9 of the judgment. There's a second page of the quotation of the judgment where I've underlined in bold. There, the point I'm making is that if one looks at the court was confronted with Entry 25, which says gas and gas works, and the court was then confronted with Entry 24, industries. Court said, if I say that gas and gas works is in 24, then of course it will fall into 52, and therefore I will Entry 25 will be left meaningless. Rather, the way court was at a situation where it says, and I'll read this just 4 lines. It's from what I've highlighted and underlined, just 3 lines above that. If industry in Entry 24 is interpreted to include gas and gas works, Entry 25 may become redundant. And in the context of the succeeding entries, namely Entry 26 dealing with trade and commerce and Entry 27 dealing with production, supply and distributions of goods, it will be deprived of all its contents and reduced to useless lumber. Because my humble submission is that by removing industrial alcohol from Entry 2, one would not make Entry 8 useless lumber. Entry 8 would still apply fully as far as potable alcohol is concerned. Here was a case where the court was trying to see what would be left with gas and gas works if I put it the entire thing in the industry. So, Millards, if that analysis is also applied, then Millards, Calcutta Gas comes to my rescue. Leaving Millards to my last point, which I've made, Millards, at para 9 of my note, is that Synthetics 2 cites India Mica's case and says that within the parameters of India Mica case, if a regulatory fee is imposed by the state, and those parameters and the boundaries are set out in India Mica's case, which is time tested and recently applied in Vama Organics 2, which was read out by Honorable Solicitor General. So, Millards, as far as regulatory fee imposition is concerned, Synthetics 2 also leaves that door open for the state. So, according to me, it's a storm in a teacup, Millards, to say that we can't do anything. If you fall within the parameters of India Mica case, you can still impose a regulatory fee. Those are my points. I'm very grateful.
Yes, Mr. Yes, Mr.
Just a very, very short compass. My submission would be only on the phrase this alcoholic liquor for human consumption. Although lordships are looking at Entry 8, the intoxicating liquor, my submissions are just twofold. The phrase alcoholic liquor for human consumption has since been long, since the Constitution has been understood as what the synthetics has said, which is to be consumed as it is. The debate has always been with regard to intoxicating liquor and the fact that whether the, something other than alcoholic liquor for human consumption will also be added in intoxicating liquor. So far as there's submissions to say that alcoholic liquor for human consumption has to be expanded to mean something capable of also has never been any judgments of a lordship except the Bihar distillery, which makes a aberration in that to say that now you can even go and impose excise duty with regard to rectified spirit, etc., which is not a alcohol liquor for human consumption. So my submission to your lordships is that with regard to this phrase alcohol liquor for human consumption, since Balsara and till synthetics too and the later judgments all have consistently as held that this phrase would mean only with something which can be consumed as it is. Whether intoxicating liquor, as what has been all argued, will also include something else, but your lordship will see, I would not wish to make those submissions on that. My only submission, I have put that how it has been followed till Utkal distilleries, this 2022 judgment of your lordships, all have taken this consistent view except the judgment in Bihar distillery. Now, Bihar distillery, your lordships may just note the fact that it applies a very simple test, which according to me is not correct, is the fact that it's a case of a mere dilution. In fact, it also recognizes the fact that it makes a potable alcohol or alcohol for human consumption only when you dilute it. So therefore, they imply there is an existence of a process, and the initial, that is rectified spirit, is not something which is alcoholic for human consumption. So my submission to your lordships is, one, the test that it is a case of mere dilution is not correct, as your lordships in Winbros, in the case of an income tax, has clearly analyzed the process and has said that it is not only a mere dilution, it has to be a case where it has to be put on a specific environment, on a temperature, by addition of many other things to make it fit for human consumption. So my submission to your lordships.
Given us a note by any chance?
Yes, your lordships, it's 2J, volume 2J.
All right.
Yes, your lordship. And one last submission to your lordship's consideration. There was a submission made that, look, today after a GST, what the states have been left with is the entry 54 is the alcohol liquor for human consumption. And then your lordship has to read it expansively. My submission to that is that, in fact, if that has been the interpretation given, there would be a substantial loss, because today, post GST, all other alcoholic liquor, including the rectified spirit and the extra neutral alcohol, all is liable for GST. So that GST also goes to state. It's not only that the center is keeping, as the lordships know, it's a federal fiscal legislation. So it goes both to states and the center. Now, apart from that, for alcohol liquor for human consumption, they have an exclusive power to impose sales tax. So my submission is that what they are losing would be, in fact, a GST in case if the expansive meaning is to be given, not there has been a loss to a revenue, because that's what Shadan.
Thank you, Mr. Pawanchal.
Deeply obliged, lordship.
Yes.
May it please, Lords. Lord, small submission, my lord, for 5 minutes I'll take it. Lord, 901.16, SLP civil number 3160 of 2015. Lord, this SLP, Lord, subject to outcome of your lordship decision, this is to be decided. Lord, on the ground, Lord, certain duty was imposed.
But what we'll not go into the facts. You can tell us what your submission on law.
Lord, my submission is they have imposed certain interest, Lord, for the duty because of the issue.
That will have to go before the regular.
Lord, the Honorable High Court.
You have to say on the questions which we have been hearing on arguments on now for the last several days.
Yes, my lord. In case if your lordship is upholding the judgment, my lord, I got benefited this respondent. Suppose overruling it, my lord, the interest should not 100%.
That you can argue.
180% it is coming, my lord. Actually, more than a crore.
Yes, all right. Thank you.
Much of.
For Balrampur Chini, just 2 minutes, your lordship, just stepping back. Now it has become a center versus state issue, which is rightly so. But it started out as me or the private party versus the state issue. And the legislation in question was the UP Excise Act, in light of which, and why we say it, because in light of the 3 issues which are before the court. The first issue is regarding entry 84 list 1 and the counterpart entry, which is entry 51 list 2. The issue regarding that is alcohol fit for human consumption. The second issue is regarding entry 8 list 2, which is intoxicating liquor. And the third issue is regarding entry 33 of list 3, which is to be, as per the other side, read along with entry 24 of list 2, which is on the industries aspect. And the counterpart entry in entry 52 list 1.
Alright, what do you have to add? apart from-
The only thing add is, Your Lordship, in the UP Excise Act, we have to see the legislative conscious from the Act itself. If Your Lordship will see the Act, because no one has shown the Act itself defines what a liquor is. The UP state says liquor is intoxicating liquor, and in what it includes, they add all the beverages. So the argument sought to be made now is contrary to the legislative conscience itself. If Your Lordship takes the statute for 1 minute,
Where do we get it? We just make a note and then.
Your Lordship, it's in volume 4, page number 682. There are 4 definitions which are important in this statute. The first is excise duty, which is at page 692. Because it says excise duty as per entry 51, list 2.
Alright, excise duty is 692.
Then definition of liquor, which is also at page 692 bottom, Your Lordship. I'll just read it out. It says liquor means intoxicating liquor and includes spirits of wine, spirit, tari, panchai, beer, and all liquids consisting and containing of alcohol. So there is no question of moving beyond these beverages or taking assistance of entry 8. The other is excisable articles, which is definition at page 696. Excisable article, they specifically mention, means any alcoholic liquor for human consumption.
Yes.
And then, Your Lordship, section 13, read with section 19 and 28 of the Act, says that any transport or removal of these excisable articles, that is to say, any alcoholic liquor fit for human consumption, will be charged with a duty. So they, in the legislative aspect, have only relied on entry 51, which, as per every submission, is barred by entry 82.
Thank you.
Entry 84. Much.
Yes, Mr. Dwivedi.
I was to answer, my lord, that Tikaram G issue, my lord, if your lordship recollects, whether it is, my lord, my submission is this, my lord. Lord, Tikaram G essentially does 3 things. A, it compares the 2 acts which were in question in that petition and says that there is no repugnancy in that matter, with which, my lord, we are not concerned.
Yes.
But second, which in my submission is an obiter because that was not required to be decided, is the term industry in entry 52 list 1 is restricted only to manufacture, neither pre nor post manufacture. And third, Tikaram Ji does not even go into occupied field and says that once there is no notified order, the scope is open for the state to step in and legislate.
Does not go into occupied.
Does not go into it and says that, but that is clearly an obiter. It was not required to be decided. There is no discussion why one view over another view. So it is an obiter. But so far as second issue is concerned,
Yes.
regarding the restricted meaning given to the term industry, there are some legislations in place as on date referable to entry 52 list 1. So they might be impacted. In future, the parliament may require, my lord, in peculiar circumstances, to control, my lord, right from raw material till the end products usage. So, my lord, I am not, my lord, respectfully, my lord, concerned with whether Tikaram G is overruled, affirmed, or explained. My lord, that's entirely your lordship's prerogative. But, my lord, kindly bear these factors in mind. So far as second is concerned, whichever way, your lordships may, my lord, accept our submission that there was no legal or other necessity to restrict the meaning of the term industry. It is wide meaning. And if it is not so, then even entry 24 list 2 also will be impacted. Because then state also will have only manufacturing part. So I am not, my lord, against state. I am saying state also would be adversely affected.
Thank you.
So these are my submissions.
Yes, Mr. Dwivedi.
Wait, please. We have compiled the rejoinder submissions also for lordship's convenience. It's a short 10 pages only, 15 pages.
Where will you find it, Mr. Dwivedi? The
Volume 1M.
this.
It's on the screen.
PG code.
Then you can scroll.
That's digital PC.
Digital PC.
Yes, on.
Then you can scroll it actually. Yes. Digital mode.
Law, as I have been taught, and as I have learned over the years, and your lordships have hammered it in, and that is, we are a federal structure, but the power of the state under list 2 cannot be controlled or regulated by parliament. That's the concept of cooperative federalism. Federalism, your lordships have churned out time and again. And if I would refer to your lordship's judgment, 2000.
Would you like to read that out? We have that para 1, para A. Let's see how you have formulated it.
No, I was responding to what was argued
Oh,
today.
right at the end. Sorry.
So the question is not, what we are being told is that in 1951, IDR contained industry and industrial alcohol and other things. In 56, it was modified to include alcohol under the heading fermentation. And then 16, again, it has been changed. Now I ask myself, is the jurisdiction of the state going to conform to the law laid down by the parliament? Or can parliament, by constantly modifying and amending its own act law, dictate what is contained in the state list? Lordships have very clearly said state list reserved for the states, and states have plenary power, which power cannot be controlled by parliament or by parliamentary legislation. That's not is absolutely clear. But yet my friends say that entry 8 has to be guided by legislation of parliament, 1951 Act. Now I ask myself, what is being argued, in fact, is that forget what the makers of Government of India Act 1935 had in mind when they incorporated NT 31, which is the same, verbatim the same as entry 8. What they had in mind when they incorporated entry 40, which is excise duty, same as entry 51, list 2. My friends further say, forget what the framers of the Constitution saw in the Government of India Act and these entries and incorporated that verbatim in the same manner as in the Government of India Act. My friends further forget the fact that the legislative history, if these Government of India Act and the Constitution entries are seen in the light of the legislative history contained both the things in the same manner as incorporated in the term intoxicating liquor in entry 31 of the Government of India Act. So what we really have to see is, what did the makers of the Government of India Act have in mind
when they incorporated entry 31, list 2. That is intoxicating liquor and in all its facets. And not anything else. No. The parliamentary law may say whatever it wants to, Parliament may include whatever it wants to, but we cannot, on the ground of parliamentary supremacy, justify this kind of encroachment on the state list. So therefore, what is absolutely essential is that before we go into the issue, whether intoxicating liquor means what I am claiming or what they are, or it means what they are claiming. No? Before that, we must be clear about the federal aspect that is embedded in our constitution. And the best judgment in that regard, not the latest one, I would submit Lordship's judgment for 2018, 8 SCC 501. That is at volume 5, PDF page 1299. The relevant paragraph note I have given my note at page 1.
Volume 8.
The emphasis is quite clear and unequivocal that state powers are plenary within their own list. They cannot be tempered by Parliament. Now, what are being
You are supposed to give your rejoinder today, right? But why this particular document is uploaded during the court hours? We are having to stress our hand and get away from the notes that we are taking with our hands. It should have been incorporated before we commence proceedings.
We can keep a mouse here.
To the technical issue, and what we are having to concentrate on the law is getting diverted. I mean, at least I'm speaking for myself. I'm not speaking for other members of the bench.
I can understand that difficulty, because since we are confining ourselves to this technology part, we can't. Obviously, there's no.
So if it was done at 10 o'clock, it would have been incorporated in our devices.
Was it 9:45, my lords? Was it 9:45?
Why not at yesterday evening? Why not today at 6 o'clock? Don't try to give a justification 9:45. 9:45, we are getting dressed for court.
Quite right.
9:45, what do you do, if I may ask you, young man?
Where is it coming to the?
You are looking at your, preparation of the court, or you are getting dressed for the court? I think we have the same routine.
My extreme apologies.
No, it's just that I am a little disturbed. That's all. Everybody.
It's inconvenient and difficult too. Not I can understand. Yes. Yes. Or if I may enlighten the entire note, this was the evening whiskey which caused the problem. But my apologies, Lord. Lordship may. My extreme apologies, Lord.
It from you.
Yes, Mr. Dedi.
I'm just to
Right.
enlighten the entire thing.
Yes, Mr. Dedi.
Now, Lord, therefore, what I was saying is, Lord, what we have to look into is, what does the Constitution provide, not what does the law provide of Parliament. Parliament would always be encroaching. The nature of power is encroaching, and they therefore always try to encroach. Now, that is why I was referring to 2018, Volume 8, SCC 501, paragraphs 94 to 120, 123 to 133, 466 to 468. And then, Lord, that 9 judges' judgment, Lord, of Jindal, in which Lord Justice Chanchud was there, Lord, 2017, Volume 2, SCC 1, Volume 12, paras 13 to 16. This is PDF page 670. 8. PDF page 678. PDF page 678.
Given the PDF.
Volume 5. Now, Lord, if I may, Lord, Lordship, since Lord have it here, can I place the A part of my?
Yes.
The words notwithstanding clause 2 and 3 and subject to in Article 246(3) are not unlimited. They are limited by the context, that is the basic structure of the dual polity. Admittedly, both the union and the state legislatures are plenary in relation to their fields. Both derive equal powers of legislation only from the Constitution. The states share sovereignty with the union, and that they are legislative plenipotentiates within their legislative fields. They are neither appendages nor satellites of the union, but are its co-equal. This is precisely what Lordships have said in 2018, following large number of decisions in the earlier. Therefore, keeping in the context in view, we have to analyze the scope of the aforesaid phrases. The issue of parliamentary supremacy arises only in the event of a conflict of entries. Kindly note this one. It arises only in the event of a conflict of entries on the 3 lists, and not in the case of conflict of laws that attracts question of repugnancy or occupied field. Not only the entries in the union list, but all the legislative entries in the other lists are to be interpreted widely and liberally. While so interpreted, conflicts or overlaps may arise, which are resolved as per the principles evolved in Hext Pharmaceuticals note. And I have, for Lordship's convenience, laid down certain paragraphs which are relevant. In fact, this judgment, Lord, Hext Pharmaceutical, which is kind of an authority for this purpose. It in fact says if there is a conflict between the entry in the list 1 and entry in the list 3 and 2, sorry, then the effort has to be to reconcile the conflict harmoniously. And every effort should be made to reconcile harmoniously. It is only when no reconciliation under any circumstance is possible, then only then this parliamentary supremacy kicks in. But then for that purpose, they went to this extent, Lord, that if the central list is a general list, that's what is considered in this thing. And if the state list overlaps the central list, then carve out a space for the state list, and then create whatever normally could be given to the center and appropriate space for the state. It's not that we will wipe out the state entry because there is a conflict. So this kind of interpretation has been followed by our lordships all throughout, and I'll show it till about the 2002 ITC. The parliamentary supremacy as held in the above case is limited and not absolute. It operates only when there is a irreconcilable conflict of entries. The irreconcilable conflict will only emerge when all efforts at harmonious reconciliation fail. One of the foremost methods of reconciliation, as pointed out, is to cut down the union entry and carve out a reasonable space for the state entry. That's what the Hicks says.
Yes.
So we should not attribute, with all due respects, we should not attribute everything to the concept of parliamentary supremacy. We should be hesitant in going to that because Lordships have said that any interpretation that whittles down the power of the state should be avoided. And this Hex Pharma, I am informed, was reaffirmed in innovative the arbitration matter. Now, bearing this in mind, let us analyze what is the scope of entry 8.
So if we have to then sort of go into the content of entry 8 which says intoxicating liquor.
And
According to you, intoxicating liquor includes all liquids which are alcoholic. Now, and therefore, it's not really something which is only which is portable or for human consumption. Can you just formulate why you are why that interpretation
exactly.
you're really
I've given a cogent reason for that. Also,
just
two sentences we can let my letter should finish.
yes. So, Mr. Dwivedi, just tell us if you can summarize them in points.
Yes.
Why intoxicating liquor, as you say, means all liquids containing alcohol. These are the words you have used in a written submission.
Quite right.
So let's just take it down step by step. Just give us the reason.
This was what was in the mind of the makers of the Government of India Act 1931.
All right. Just one second. This was how the makers of the 1935 construed the phrase. Now, when you say this was how the makers of the GOI Act 1935 construed the phrase,
My lord.
what is it? How do you support it?
Yes. Now, Lord, when we see the entry 31 in the Government of India Act 1935, then naturally we'll have to find out from where did they get this.
What is the entry? What is entry 31? Can you just again?
Intoxicating, verbatim the same as in.
Verbatim the same.
Verbatim. As in entry 8. I mean, it included certain other items which included opium.
Right.
With which we are not concerned, so I was not wasting lots of time. And when it came to entry 41, another important thing is, which lends credence.
What did it include apart from opium?
Yes, I got the Government of India Act.
Sanskriti, is that in somewhere in our one of our compilations? Entry 28. Oh, sorry.
As a written submission.
So that we don't have to again hunt for them. Can you just tell us which volume?
Volume 4 is page 1.
Mr. Tushar Mehta, Sanskriti?
2G. 2D.
2D. Page 28.
No. In the yes.
Yeah, we got
Government of India Act. I got a Government of India Act.
Yeah, we also got it now.
Yes.
Entry 2D, volume 2D, page 28.
Yes, Lordship will stop at intoxicating liquor from the word starting with opium, other narcotic drugs, but subject as respects opium to provision list 1 and respects poisons and dangerous drugs provisions. So up to liquor is intoxicating liquor, that is to say,
the Lordship now compares right from opium to the end, all the other words are different.
And I would request Lordship to ignore that, that's
Yeah.
not relevant for our purpose.
Lordship wants the original text I've got.
Yeah, that is to say the production, manufacture, possession, transport, purchase and sale of intoxicating liquors.
Stop.
Right. So everything from opium up to the end is deleted and narcotics drugs is deleted. Yes. All right, we got it. Then
Now, the question is not what did they have in mind and where did they get this from? There is entry 41 also of the Government of India Act, which is important, Lord. Entry 41 is the taxing entry, not excise duty, which is verbatim in the same form as it was in the Government of India Act, entry 41. Entry 51, list 2 of the Constitution is verbatim the same, Lord, so far as the relevant part is concerned, verbatim the same as entry 40 under the Government of India Act.
entry 40, right?
Entry 40, Government of India Act 35. Now the question is, these two phrases were not new phrases. These two phrases were not which had not dawned all of a sudden under the Government of India Act. These two phrases are well understood and utilized in various local acts, excise acts. And that is where I'll kindly have my written submission, the original written submission, and I'll refer to 2-3 pages only. Because that's the key stone of my entire argument. Both entry 31 and entry 40 in the Government of India Act were verbatim borrowed from the local acts. Now, it is, if your Lordship would kindly come to my original written submission, volume 1, A, page 8.
Yes.
I had referred earlier also, but then since you Lordships want to know.
And according to them, according to you, therefore, that this had meaning, it was not a meaning which was confined to, it was not confined only to potable liquor.
Yes, initially these local acts used liquor, which included all kinds of liquor, all liquids containing alcohol, including denatured. Then, Lord, comes the Madhya Pradesh Act, Lord, at page 10. The convenience, I have only quoted the definition clauses, Lord, of those acts. Lordship would have page 10. MP Excise Act, excisable article.
So according to you, the meaning in the local acts was
adopted.
All right. Then what is the next point, Mr.?
No, but kindly just have a look.
We've got your point that entry 31 and 40 were borrowed from the local acts, and therefore they must have the same meaning as in the local act. It includes.
What I wish to point out here is, not permit my little insistence on that too.
Yes.
For entry 50 and 40, list 2, sorry. The Government of India Act follows the definition of excisable article, which says alcoholic liquor for human consumption. Excisable obviously means tax. So it uses that phrase. But when it comes to liquor, which is section 2 of the Act, it means intoxicating liquor and includes spirit, wine, spirit, and all liquids consisting of or containing alcohol. Spirit is defined to mean all liquids containing alcohol. Now, what is interesting here is, none of these acts, when it comes to regulatory power, dissect between the industrial alcohol, the denatured spirit or the rectified spirit and the potable alcohol. They don't. None of the acts. And these acts were of vintage 15, 1915, 1908, 1910, 1912. The only dissection which these acts had was in respect of excise duty, where it was said alcoholic liquor for human consumption would go there. And of course, the Dominion wanted its share of the pound of flesh. Therefore, they said we'll have the industrial or the non-potable there, excise duty. The Constitution has verbatim borrowed and adopted the same system. Now, I ask myself, for excisable article for the purposes of levy of excise duty, the phrase used is alcoholic liquor for human consumption separately. There's a dissection. Rectified spirit and denatured spirit may not fall there, but for human consumption, therefore, potable. But if the idea was to have the same meaning here of liquor and intoxicating liquor, why would they not put the same word here? But instead of that, all the acts unanimously did not dissect for regulatory exercise of power, not the liquors. In fact, if your lordship would see section 213 of the liquor and all the acts, it says all liquids containing alcohol, which means alcoholic liquor. So alcoholic liquor was in the regulatory regime, while the alcoholic liquor for human consumption was for taxing regime. That was the dissection created by the local acts, followed by the Government of India Act. And why do I say please adopt this legal sense? Because the lordships have in Gannon-Dunkerley, the lordships were confronted with this similar issue exactly. Taxes on sale of goods. That was the word used in the Government of India Act. Lordships went into a history. How did this term taxes on sale of goods come? And then the lordship said that we must see the legal history of the term. How was it used in England as well as in India? And then they hit upon this Sale of Goods Act 1930, which was close proximity to the Government of India Act. And they said that definition must have prevailed because that was the legal sense prevailing at the time when the makers of Government of India Act applied their mind. No, it's not that everywhere we adopt this theory of popular sense or any other sense. Question is, Gannon-Dunkerley Constitution Bench clearly says, if there is a choice between popular sense or the legal sense, then we will adopt the legal sense born out of history, legislative history. This is Lord 1959. Lord, if your lordship would say, Gannon-Dunkerley is 1959, volume 1 SCR 379. It is volume 5B, sorry. In fact, they discarded the popular sense and said, no, it's a sense in which it was understood by the makers. And what was that sense? Legislative history. Sale of goods. Now I ask myself, what is the difference between that case and this case? Note, why should that principle not be adopted here? The question to be, as I said, note, I repeat again, the question to be asked is not what the makers saw and thought, but the question to be asked is what the makers of the Government of India Act, that is British Parliament, saw. And what was the legal sense prevailing in which they saw the term?
Omar, you cited Justice Chagla's Balsara judgment. Can you just give us that cross-reference once again?
429, volume 5F, Manoj, the Bombay High Court. 429, volume 5F.
That judgment is again based on strong and
Can you just go to that, Mr. Because that's the con. We have Balsara, which reverses Chief Justice Chagla's interpretation.
Balsara is the only case which deals with the legislative history, no other case.
Right.
Even synthetics doesn't deal with the legislative history, silent on that. Balsara is the only case which had adopted, in my opinion, the right approach as indicated in Gannon Dunkerley, though it did not notice that judgment, but verbatim the same situation. So the choice before your lordship is to whether to rely on the legislative history and the legal sense which prevailed at that time, or to adopt some kind of a popular sense which may keep on fluctuating, and so will the entry. And that is the difficulty I sincerely wish to point out. My friend says in 51, IDR included power alcohol and industrial alcohol. Then in 56, they changed it to alcohol, which means including even potable alcohol. Then in 16, they again changed it. And then my friends say, please rely upon the Law Commission's report and the legislative debates of Parliament. How can they possibly not solve the riddle? I ask myself, not before your lordship. The issue is the interpretation of a constitutional entry. And entry 8 does not conflict with any central entry in the central list. So there's no issue of conflict. And if my submission is correct, that entry 8 includes, as I'm advocating, then perhaps where is the conflict, I ask myself? Where is the occasion to attract Article 246 of federal supremacy? Federal supremacy certainly cannot mean that we can snatch every entry from the state list. Because fact is not, if your lordship would recall 369, Article 369 clearly enabled Parliament to legislate on any state entry for a period of 5 years. Therefore, virtually every entry was within the sway of Parliament. But 369 was given a limited life of 5 years and expired. But should we still continue to adopt that?
Balsara is under the government of
Look, there would be another confusion which I may indicate if lordships would not adopt my interpretation of this word intoxicating liquor. Intoxicating liquor contained all liquids consisting of alcohol. And therefore, under the Excise Act, they were being regulated, even medicinal and toilet preparations were being regulated therein as liquid containing alcohol. The non-potable liquor was also being regulated under the Excise Acts, local acts. Now, I ask myself, if we limit the definition of intoxicating liquor to potable alcohol, then there is no entry in any of the lists which provides that regulatory power will be exercised by any of the state or the center in respect of alcoholic liquor not for human consumption. Where will that go? I ask myself. Likewise, medicinal toilet preparations containing alcohol, where would they go? I ask myself. And the answer has been provided. The Indian mica and macanite Constitution bench of 71 says rectified spirit and industrial alcohol, which is raw material to macanite industry, would be covered here, entry 8. And Lordship would recall, Lordship has seen Lord Southern Pharmaceuticals, where medicinal toilet preparations containing alcohol were included in entry 8. Not the whole situation is we have been following the legislative design created in the local acts, so far as alcohol is concerned. That has been followed all throughout the Government of India Act, and from there we have adopted it in the Constitution of India. Now we are saying segregate because the IDR says so. IDR wants, Parliament wants, maybe so. That's the desire of Parliament. Every power structure wants more power. As the saying goes, bro, the popular saying goes, "Dil always mange more." But question here is, can we curtail the scope of that entry? That's the point note which I was emphasizing on. And we cannot unless there is a very cogent reason to show otherwise. Mainly because industry is included in IDR. Now, some of the arguments were that industry, if intoxicating liquor, let's test it another way. Some of the arguments raised were that the intoxicating liquor, being potable liquor, will fall under entry 8, but the non-potable liquor will go toward industry in entry 24. Because if it doesn't go there, it can't go to entry 52. Now, Lord, I ask myself, Lord, if the framers, looking into the background, were adopting the scheme of Government of India Act and the local acts, why would they put alcohol not for human consumption in word industry in entry 20?
The Constitution uses the word intoxicating,
I'll
both in Article 47 and in entry 8.
I'll answer that. Lord. I have
Right?
one. I'll answer that.
So if it is used the same expression in both these, can that expression intoxicating have a different meaning in Article 47 and a different meaning in entry 8?
It will, and I'll show
And
why.
if it is to have the same meaning,
Yes.
then in entry 8 also it has to be intoxicating for the human being, isn't it?
I'll answer that. No, there's no difficulty in that. Intoxication word certainly implies the human factor. That it should be intoxicating to the humans. But does it mean that it should be as a beverage causing intoxication to the humans? Or can it mean also liquor which is capable of causing intoxication to the humans? The dictionary says intoxicating means both the things. That causes and is capable of causing intoxication.
But
to
what
humans.
is capable of causing is not something which is drunk normally. A beverage is a normal drink.
I'll tell you what.
That is an abuse of that.
But that may not be, with due respects, that I'll so this.
Chief Justice Chagla, my learned brother, Justice Rishikesh Roy just pointed out, in the opening paragraph makes a distinction between the consumption of drink and foreign liquor and its application. And he then refers to also the fact that, it can be used, for eau de cologne. And he's also accustomed to the use of eau de cologne and lavender water. So he's made that distinction in the very first paragraph.
Important part is, and I went through that judgment more than once, no? Does it at all, I ask myself, refer to the legislative history, the Government of India Act? Because that was an act, remember, that was an act made under Government of India Act.
We may just benefit by reading the first sentence of Chagla's judgment.
Yes, yes.
Yes.
Let us read that first sentence. It's at volume 5F, 429 Omer.
Yes,
One is to
429.
drink, the other is to use.
Right.
One is to drink.
Page 434. Here, we'll start. Yeah, we have. The first paragraph, Lordships refer to. Yes. This is a petition by one Pram Nusirwanji Balsara, who is a citizen of India, has in his possession 1 bottle of whiskey, 1 bottle of brandy, both partly used, 1 bottle of wine, 2 bottles of beer, 1 bottle of medicated wine, 1 bottle of eau de cologne.
Good old Balsara would probably not realize, at that time, that he would be still living in the annals of our history.
It's partly used.
Partly used.
It's really intoxicating.
No,
Anyway.
the sentence should be finished.
Lavender water and some bottles of medicinal preparations. He alleges that he has been.
Before that,
No, before that,
medicated wine.
Immediately after that.
medicated wine, then rest of it, please read. 1 bottle of medicated
beer,
wine.
1 bottle of medicated wine, 1 bottle of eau de cologne, 1 bottle of lavender water, and some bottles of medicinal preparations.
We have an entire picture of Mr. Balsara captured by Justice Chagla in that one sentence.
Now, my lord, finally notice that this is in the context of the Bombay Prohibition Act, not the Bombay Excise Act. I have placed before your lordship not the Bombay Excise Act, but the definition of liquor includes everything. But besides the point, Lord, since your lordships were
Next sentence also,
very well.
what he drinks and what he uses.
That's important.
Yes.
Lord, that was the case confined to what was caught with him under the prohibition law. And therefore, what he was trying to explain was in terms of what was caught with him. Those were drinks, there's no difficulty. But the point is, does it necessarily mean that whatever he had will confine the jurisdiction of the state under Entry 8? Lord, I am on an issue where the legislative entry of state, which your lordships have not said is plenary for the state, would it be confined to these drinks only? As the legislative history shows, from local acts to Government of India Act and then the Constitution, it does not. The question here is, lordships were, perhaps it seems, affected by the word intoxicating drinks coming in Article 47. But kindly notice last 2 lines very carefully. The state shall endeavor to bring about prohibition of consumption except for medicinal purpose. That means prohibition of consumption except for medicinal purposes of intoxicating drinks. In other words, medicinal purposes would always be there liquid. State can control. But it will not prohibit. Kindly notice the distinction. Not prohibition is for drinks which are consumed as it is, not beverage. So what 47 is advocating is that you prohibit the consumption because the idea was prohibition. But you will not prohibit medicinal purposes. State will not prohibit medicinal purposes, though it may regulate that. of intoxicating drinks. Now, word is intoxicating drinks, which normally one can associate with the consumption as it is, the beverage. But if the idea of entry 8 was the same, then why not use the word intoxicating drinks there, I ask myself. Why have different words for the same thing? At every place, note, entry 8, then perhaps note 47, then perhaps note in entry 51, list 2. Why do they not, again, there's another answer to it, not why the framers use the phrase alcoholic liquor for human consumption in entry 51, list 2? If it meant beverage, as in entry 8, then the same thing could have been used here. I ask myself why, not the question, not the immediately crops up, not why use two entirely different phrases to denote the same thing. It was very convenient. They could have used, if intoxicating liquor meant always the liquor which can be had as it is and consumed, then the same could have been used in entry 51 list 2. So 51 list 2 doesn't use that term. But instead it uses the term that was there in the Excise Acts. It follows that. When the Excise Act distinguished and dissected between the liquor that is potable goes to the excise duty and non-potable goes to the regulatory. I'm not again, not I would be kind of repeating myself. Intoxicating liquor borrowed from the Excise Acts. Alcoholic liquor for human consumption for entry 51 list 2 borrowed from the Excise Acts. Then why should we confine the meaning of intoxicating liquor? It has been borrowed from the Excise Acts. Not word intoxicating has to be understood widely. Your lordships have always said interpretation of an entry is always wide. So let us interpret it widely. Would it not include both liquor, which when had as it is as a drink, causing intoxication, or liquor capable of causing intoxication to the humans? For instance, rectified spirit, Lord, as I explained earlier, rectified spirit is nothing but alcohol which is diluted by pouring water into it and then drinking. As I had given an example, Lord, even normal whiskeys, normal people have it with soda or water. But then it doesn't cease to be intoxicating when it is in bottle.
So what is the proposition? What is the proposition that you formulate?
The proposition is this, Lord, that the word intoxicating liquor has to be interpreted in the light of the legislative history.
Yes.
That is the legal sense. And therefore will include all alcoholic liquors containing alcohol. This is because Gannon Dunkerley says so, Lord. I submit with respect. Look, this judgment of Gannon Dunkerley, which I wanted to place on the earlier occasion, I'm sorry. judgment is Gannon Duncally's case. Kindly have that judgment, but I will not place it for lordship. I have at page 4 of my written rejoinder written submissions, I have referred to it. 1959, volume 1, SCR 379. It's in volume 5, 5B, B for Bombay. I'm sorry, but the term comes, Bombay comes really.
B page
Page 486, PDF page.
at
Volume 5B.
But the judgment pages are not 59 1 SCR 379, pages are not 390, 391. Three 391, 397 to 416. And it's a classic case where they considered whether they should accept the popular opinion or the legal sense. And they said, no, we should adopt the legal sense. And that is why Lord Gannon Duncally adopted that legal sense. It referred to large number of decisions. Because that gives an element of certainty. Otherwise, it will keep on vacillating. Secondly, the another important aspect of this argument is entry 51 list 2 is a taxing entry. Now, Lordships have settled it more than once, note that taxing entries are separate, the general regulatory entries are separate, and they do not cast any kind of shadow on each other. Now, here is a case where we are being told to interpret the regulatory entry in the light of the taxing entry. Should that be done is the question. If Lordship would permit me to place this, I have elaborated this, these 5-6 points which are essential, and that will conclude the matter earlier.
yes, let's quickly go to
Yes. Page 3, it begins, no? This is PDF page 4, perhaps. It begins.
yes.
The scope and expanse of the word intoxicating liquor, in short, IL, have already been explained in my written submission at pages 2 to 20 under the heading A1 to A7. There is a need to analyze this phrase in light of the legislative history as explained above. Have not got it. Yes. The question to be asked is not how the framers understood it, that is its legal sense, but as to how makers of the Government of India Act 35 saw it. When they coined this phrase IL, the legislative history, as in US or UK and the local excise laws and all, had already determined the meaning of intoxicating liquor as including all liquids containing alcohol, including denatured spirit, medicinal toilet preparations containing alcohol, etc. With this background, the makers of the Government of India Act utilized the phrase intoxicating liquor in entry 31. They further used the phrase alcoholic liquors for human consumption. Not the word is not fit for, but for. In entry 40 list 2, it is therefore reasonable to assume that they utilized both intoxicating liquor and alcoholic liquors for human consumption in the same sense in which they had depicted in the local laws as shown in pages 8 to 12 of the written submission. If the intent was otherwise, then the framers and the makers of 35 Act would have simply used the same phraseology in entry 8 list 2 as in entry 40 list 2 of the Government of India Act 35 or entry 51 list 2 of the Constitution. The two entries use different words and therefore have to be separately seen as in the light of the legislative history. The sense that emerges from legislative history is the primary sense as can be gathered from the following cases I have referred to. There is no parallel legislative history in any of the lists that may confer regulatory or controlling power in relation to alcoholic liquors not for human consumption, medicinal toilet preparations containing alcohol. The absence of any general regulatory power as above in any of the lists further corroborates that they were assumed to be under intoxicating liquor in entry 8 list 2. This again as per the local acts. That the local laws clearly defined and equated intoxicating liquor with all spirits, all liquids containing alcohol, including denatured spirit. The denatured spirit was a spirit being included in intoxicating liquor. This also is a way to, in a way, explains why word alcoholic liquor for human consumption not used in entry 8 list 2. There is no liquor that does not cause intoxication. Even denatured spirit causes intoxication. It has been denatured to prevent people from consuming it. Lord, what happens is when the denaturant is put, as per the local excise laws, a denaturant is put that makes it nauseous. Therefore, you don't have it. But it's not that the alcohol content goes. Alcohol content is there. There is a renaturation process. You can renature and then have. Therefore, to cut down regulatory entry 8 with the aid of taxing entry 51 list 2 by equating the two would not be very constitutional. Entry 8 is an entry that uses general words and therefore has to be interpreted widely. It is not made subject to any entry, unlike entry 24, 26, 27. Therefore, to make it subject to entry 52 would be impermissible. The dictionary meaning of the word intoxicating includes both the liquor that causes intoxication and the liquor that is capable of causing intoxication. I have annexed one of the meanings. It is further not permissible to determine the scope of entry 8 list 2 in the light of parliamentary laws enacted post-constitution and entry 52 list 1. This is amply settled by the above constitution benches. Otherwise, there would be grave risk of making the state appendages of the union, destroying the delicately balanced federal structure. The above shows why intoxicating liquor in entry 8 is wider and different from the phrase used in entry 51 list 2. It cannot be cut down by entry 51, taxing entry. Following points need to be analyzed, and this is a reiteration of the same, which I have indicated above. Accepting, Lord, if Lordship would have it from page 7 top notes. The Constitution does not use industrial alcohol. This phrase is not a constitutional phrase. It's not there anywhere in the Constitution, any of the entries. And there is no general entry under any list stating industrial alcohol. If intoxicating liquor is potable liquor, it is clearly shown, while IA is nowhere shown, industrial alcohol is nowhere shown. To be traced, and therefore nowhere shown, to be traced by the courts through complicated logic. There is no entry for medicinal toilet preparations containing alcohol, etc. The reason is these were all included in intoxicating liquor, always as legislative history shows. Now, there are two cases not which deal with the industrial alcohol. Incorporating it in entry 8. Indian mica and macanite, paras are given. Then in 1980, volume 2 SCC 441, paragraph 12, 15, 16, 17. No, this is not. This is, this is first synthetics, the earlier. Then I have also already referred to that Southern Pharmaceuticals, which includes medicinal toilet preparations containing alcohol in entry 8, expressly includes. That is 1981, volume 4 SCC 391. 1981, volume 4 SCC 391. This is PDF page 1985. Volume We have, then up to page 8, my lord, I have given the reasons why intoxicating liquor would include all liquids containing alcohol. Then comes the next point, my lord, the scope of entry 52, list 1. Now, my lord, it is quite uncanny kind of a thing, my lord, that this question of word industry in entry 52 is wide and expansive and includes both raw material and the end product. Though, of course, I've referred to the judgments which have rejected this contention. But my friend relied upon the debates which he had annexed with the written submission. But before that, note, there is one judgment which is so well directed as well as well considered, I mean, where this point is well considered, is 1996 Allahabad, full bench, 1996 Allahabad, 135. It's a full bench, AIR 1996 Allahabad, 135. It's a full bench judgment. This is volume 5, PDF page, volume 5, PDF page, 2274. And kindly permit me to place this judgment plot, and I'll place what my friend had placed in support of his debate. In fact, that supports my cause rather than their case. In fact, the debates prove that the Tikaram G was correct. Volume 5,
PDF page 2274.
PDF page 2274. And the relevant paragraphs I may give to you, Lordships. Paragraph 7 to 9, 12 to 21, 12 to 22, in fact, no, I'm sorry, 32 to 39, 47 to 51, 53 to 64. All these arguments were raised in the debate before the drafting committee, and the drafting committee rejected the claim that the end product regulation, which is incorporated in 18G and then entry 33, should be put in entry the 52 list 1. That was expressly argued, pressed, and the drafting committee rejected this submission and said, no, we'll put it in list 3, entry 33. The reason was, they said, that we need states' cooperation in these matters. Cooperation where they know the local condition, and they will accordingly devise their ways and means. That is what the Lordships refer to cooperative federalism. Entry 33 is about that only. It refers to all that my friend had annexed. Would your Lordship want me to place it for Lordship? It's an interesting reading, but that's why I was.
So shows just the relevant part, one para, which is.
No, the relevant part is not in one paragraph. That's the difficulty. It's in various paragraphs, one after the other. But the relevant part regarding the debate.
You can just formulate, the question is formulated at para 1. You may read that and then you may read the conclusion.
Very
Justice Khare judgment. Whether by virtue of Section 18G.
Whether by virtue of Section 18G of the Industrial Development Regulation Act 51, the state legislature stood denuded of power to legislate regulating supply, distribution, and price of molasses, a product of sugar industry, and was consequently incompetent to enact Section 7. This is the case where the molasses, which is byproduct of the sugar industry and therefore raw material for liquor industry. So this was an industrial byproduct, which is product of the sugar industry manufacture, which is a controlled industry. Therefore, where will it go? That was the question. Entry 33, list 3. And then in at least 5, 6, or maybe more, they have come to this conclusion that the framers had clearly rejected this ground that the entry 52 should be wide and it should include the end product regulation as well as other things, raw material. And they confined it clearly to production, leaving it to entry 33 is where states could also exercise power. Cooperative. And this is where they examine from page para 16. Paragraph 16. Again, the same logic, not the legislative history, has to be looked into. But it starts actually from paragraph 14, where the judges have utilized Shiva Rao and his narration of the debates and so on and so forth. Then it goes to 16, where they clearly hold that the drafting committee rejected the claim of putting it in entry 52 list 1. And then their lordships go into the issue of how to examine the entries in the light of the federal structure features. And then they deal with surprisingly, every time this question was raised by the eminent counsel Shri Shanti Bhushan, every time, because he was really he was the leading lawyer for the sugar industry, so therefore this question rose frequently, and he raised it up till 2002, Lordship. The same argument. The uncanny part is not that the same argument is raised time and again, relying upon the IDR Act for curtailing the expanse of states' power under entry 33. And the same argument is rejected time and again, and I have narrated those 8-10 decisions where this argument has been rejected, at times with a reprimand. So this judgment, if read carefully, categorically rejects and dismisses their contention that industry word in entry 52 list 1 is very wide to include the end product as well as the. Now this judgment has been affirmed in 1998. 1998, 7 SCC, page 26. In fact, lordships need not take the trouble of writing it, but I have indicated in paragraph page 12 all those cases where this has been approved. Page 12, kindly have. And can you see the times in which, the number of times it has been rejected, and at times with a reprimand to the council for raising this. It starts from 56 SCR as the first case, goes on till 2002. Not the other ones, but 2002, volume 9 SCC. This is ITC. And interestingly, Sri Shanti Bhushan has been raising this argument from 1980. That is Ishwari Khaitan, 1980, volume 4 SCC. Every time it was rejected. Now again, the same argument is being raised on the basis of very same debate which has been repeatedly rejected.
What else, Mr. Dvedina?
I'm sorry?
What else remains?
Yes. Now, Lord, the question is, Lord, this is, Lord, this is not only approved in Lord SEAL, Shriram Industrial Syndicate, but this is approved in Balsara, the Constitution Bench. This is again approved in ITC, this judgment, full bench. Lord, in ITC, which is 2002, I have narrated in page 12, and I have shown that. I've given the paragraphs. Then kindly come to page 10 of my this thing submission plus. Page 9, I have narrated those cases which have upheld.
Yes.
Then note page 10. The important aspect is not which one of the things which my friends are raising, not this document, this argument of a composite kind of a law made, which is code unto itself. And therefore, even if you don't legislate anything under the law,
Forbearance
it is vacant because there is regulation by abstinence, that's what it says. Now, there are two things which I wanted to point out. Kindly have section 18G.
We'll come back after lunch.
Apologies to Justice Roy in the first place, Lord. I have given a submission 1-0, but I gave it this morning because all the submissions came on Tuesday afternoon. I was in Calcutta yesterday, but I hand wrote everything, not it typed. So I won't refer to it, Lord, since it was after 10 o'clock, but I will just.
Now. It can be incorporated at lunch now. You can just give it to the court.
Already given in the morning, but since the Lordship said not.
Uploading on the drive now.
But in fact, Lordship may make it as a part that all submission must come 24 hours in advance. So then all of us will be. But this what happened was all the submissions.
My apologies, Lord, for the inconvenience to your Lordship.
No, not to you, but I think Samar Vijay, right?
Yeah.
Samar Vijay, actually, I should not have spoken in that fashion. So firstly, my, regret that these kind of words came out. But let me just put this thing. You see, when it is all paper court, whenever arguments are, we are making notes with our pen, ink, pencil, whatever, right? Now, this 9:45 thing has deprived me of this. That is the thing, right? So don't take it this thing, but it's just a matter of convenience only. That's what we say.
In 1-0, I was just attempted to answer this 6 questions referred by Lalta Prasad. Ironically, entry 8 was never referred to, but we have argued most on entry 8.
That's right. Mr. Dwivedi, another 15 minutes so that then we can hear Mr. Datar for about.
I'll take, I'm not going to rapid fire, just 25-30 minutes. Just 3 points I'm going to go.
But what I intend, subject to your Lordship's approval, you have noted their submissions. I can't argue. There can't be a surrender. Their new fresh argument on one side and our response on the right side will file by tomorrow or day after.
Now, then they'll go on. We'll keep it at that now. So
there are some new
they will also respond to that. They will also then respond. It will be like impossible.
I leave it to you.
This is already what we have said.
So, Mr. Dwivedi, till 2:15, then 2:15 to 2:45, Mr.
Try my best to take it.
I'll take 10 minutes.
So we'll wrap up by.
Would my Lord be sitting in alternate bench?
This will never end. Right. We'll see after Mr. Dwivedi ends. First, let Mr. Datta start at 2:15. 2:43 then we'll see how much time we have.
1-0.
Yes, Mr. Dwivedi.
But I was at page 10, last line of my submission. There's only 3 more pages and then I conclude. D, Lord, at the bottom.
Okay.
After 1996, I've given the issues settled in that case. 1996 Lavad 135, Lordship, sir, I've already referred to. And this is, as I indicated, approved in Seal's case, 98 Supreme Court. Then Balsara also, 99. And ITC, which I have given in the page 13, 12. I will kindly come to paragraph D, item D, page 10 at the bottom. Of written submissions, which Lordship was seeing. Scope of inconsistency or conflict, which was very seriously addressed by my friend. Does it require that the field ought to be actually occupied? Because according to my friend's argument, there's a code by itself laid down, IDR Act, and therefore. But this concept of code vis-a-vis IDR has never been accepted, because fact is the entry 52 is very limited. Doesn't cover the raw material nor the end product. So therefore, IDR by itself regulates production as per the Constitution. Now you may not infiltrate onto other topics incidentally and otherwise to sustain the law, but then actually the term industry denotes, and which Lordship has seen host of cases. Now, Lord, the claim of the union is that Parliament has evinced an intent to cover the whole field, and therefore, even if no order is issued under Section 18G, it makes no difference. It is the occupation of field by abstinence or forbearance. For this, they have relied upon the cases, following 2 cases relating to mines and minerals. But curiously, as I said, it is quite uncanny that every time when this question is raised about the expanse of entry 52 to cover both the raw material and the production, then they invariably go on to the mines and mineral cases. And Lordship would see right from 56 onwards till date, there has been quite a distinction drawn between the 2 categories, 52 list 1 and 54 list 1. 54 list 1 relates to entry 23 list 2, and 52 list 1 relates to entry 24 list 2.
Yes.
Now, Lord, entry 23, as I had indicated, if you also could very kindly come to this 96. And these are the 2 cases, Lord, which are invariably referred to. Invariably. And this is what is explained here and approved by Lordship in Supreme Court. It is PDF volume 5. PDF volume 5. PDF page 2274. The relevant paragraphs are paragraph 54 to 57. 69 to 72 of the PDF. And again, those 2 cases are referred. And then can you have paragraph? Can you have 71? That is PDF page 2294. I'll place only these 2 paragraphs slightly, then move on. The cases referred to above relate to grant of leases. Have Lordship heard? Imposition of cess and royalty and collection of fee in respect of mineral rights and mineral mines and mineral development regulation act. No doubt these cases at first sight support the contention of learned counsel for the petitioners.
Mr. Dwivedi, which para you are reading? I'm just
Para 70.
70, volume 5, page
2274.
2294. 2294.
229.
May I place it? No doubt these. I'm sorry.
229.
It's not there. Shriram Industrial.
Shriram Industrial.
Ah, correct.
That's 74.
227. 2294.
confuse me. May I proceed? No doubt these cases at first sight support the contention of learned counsel for the petitioners, but on scrutiny of the relevant entries of the Schedule 7 show that the cases relied upon by the learned counsel for the petitioner are of no assistance for the proposition of law advanced by them. The cases referred to above relate to entry 54 of list 1 and entry 23 of list 2 of the 7th schedule. The perusal of entry 23 and 24 would show that entry 23 of list 2 is entirely different in its content than entry 24 of list 2. Entry 23 of list 2 deals with the regulations of mines and minerals subject to the provisions of list 1 with respect to regulation and development under the control of the union, whereas entry 24 of list 2 relates to industry subject to entry 7 and 52 of list 1. On comparison, it will be found that the entry 23 of list 2 deals with mines and minerals, which is industry as well as product. Whereas entry 24 deals with industry only and not with the product of the industry. Since entry 23 is subject to the provisions of list 1 and as such, as and when the Parliament enacts any law under entry 54 of list 1 for regulation of mines and mineral development, the contents of entry 23 relating to mines and minerals shift to entry 54 and thus the state legislature is denuded of its power to enact any law on the subject. That's the case because there the entry is wider. Now, my lord, kindly bear in mind, Lord, there was an observation in the Hingi Rampur's case and Tulok's case that even if law is not made, rule is not made or regulation is not made, field will still be occupied because of the Composite Act. The reason is this, Lord, because nothing is left for the state. The entire entry goes to the center. Once a declaration is made under entry 54, both mines and the product both go to the center. What is the state going to legislate on? They are totally denuded. And therefore, whether they make the rules or not, or regulations or not under the law, it makes no difference because there is no scope available in the state list. The list itself goes, the item itself goes to the center. So therefore, this reliance on this theory of code by itself and therefore perhaps the entry, when the field is occupied and the legislation by abstinence therefore will hold the field is not correct. This analogy with the mines and mineral cases is totally incorrect. Secondly, Lord, what is important is, if you see section 18G, for a moment.
Does not apply here also.
Of the Act, not IDR Act. Do your lordships have it, or should I give the volume number? Lordships have. Power to control. But kindly see what chapter says. Control of supply, distribution, price, etc. of certain articles. Power to control supply, distribution, price, etc. of certain articles. 1. The central government, so far as it appears to it to be necessary or expedient for securing the equitable distribution and availability at fair price or any article or class of articles related to any scheduled industry may notwithstanding anything contained in any other provision of this act by notified order provide for regulating the supply and distribution thereof and trade and commerce therein. So what does it say? Not I ask myself, but it says by a notified order, you can provide for regulating of supply and distribution, trade and commerce of the commodity, the product. Now, the control has to be exercised through an order, which has to be for regulating. Now, but if the center doesn't use this power and keeps silent, or as my friend said, abstinence, does it mean that it wants to regulate or it is regulating the supply and distribution? It's a positive order which is incorporated, which is required here for purposes of regulation of industry.
But the center not regulating by a notified order is also consistent with its having formed an opinion that it is not necessary or expedient for securing the equitable distribution and availability at fair price.
I'll answer that.
It's not just an issue of forbearance. The center may feel that the conditions precedent are not satisfied and therefore we will not regulate.
Fair enough. But then
Can any other authority say that, look, according to us, the conditions requisite are satisfied?
no, when the question arises of a conflict with the state jurisdiction and the central jurisdiction under NT33, then there must be much more than what the center tries to indicate by abstinence. There has to be some indication. If the center wants to regulate by no regulation, then it must pass an order and say so. But it does not mean that I am not going to regulate and I would not allow others to regulate also. Your Lordship would recall that statement of just Mr. Govind Vallabh Pant, the paragraph which my friend had relied upon. While answering the queries, what he said was, we believe in cooperative federalism and therefore we want to leave space for the state. We want, because these are the matters which are locally better understood and locally better managed. Therefore, we want to leave it. So, kindly have note 18G provides explanation. Where will it lead to? In this section, may I kindly have the explanation? In this section, the expression article or class of articles relatable to any industry, a scheduled industry, includes any article or class of articles imported into India which is of the same nature or description as the article or class of articles manufactured or produced in the scheduled industry. Now, here is a case where imported article is taken in. That is not manufactured in India. Obviously, industry will not take in. The word industry cannot visualize such an article because it is not produced here. The question is, you don't regulate, you don't allow states to regulate. For instance, take the clause 18G2A. For controlling the prices at which any such article or class of articles may be bought or sold. Controlling the prices. Now, Lordship has seen that under the Constitution, price is 2034 in the list 3. State can exercise the power. But by doing this, what you are doing, by abstinence, you are saying even state cannot fix the price of the imported product as well as the local product. Not, as I said, not 33 has to be read in the sense of a cooperative federalism, where some space should be left for the state, as I'd place that portion of Sri Govind Vallabh Pant.
But if it is a declared industry under entry 52, the power to regulate prices will be traceable to entry 33.
34.
33.
No, it may not, because there is a
Because
specific
trade and commerce in. Trade and commerce will include all facets of trade and commerce.
No,
34 says price control. 34 says price control.
so which means we are
Price control is not abstracted or accepted away from entry 33. In respect of declared industries, all trade and commerce will be governed by entry 33.
I would not make
That
an
would
issue on
include
that.
the fixation of price.
There's no issue on that. You included in entry 33, you included in 34. It doesn't matter because jurisdiction is the same for both.
Right.
Both the state, center and the state will have the jurisdiction. What I'm saying is the consequence would be that once you lay down a law broadly and provide for making a regulation, don't make a regulation and say that, for instance, Essential Commodities Act. Lordships have the experience of Essential Commodities Act deals with foodstuff. Now, foodstuff, there they have this section 3 which says central government will make rules, I mean the order, issue orders to regulate the supply and distribution and price of the commodities. But supposing central doesn't make anything, but would the state be
No,
deprived?
the center doesn't make it because it believes that the conditions precedent under subsection 1 are not fulfilled.
Issue.
Then, if we allow the states to do it, that would really defeat the purpose of entrusting to the center the power to make that
As I
condition
said,
precedent.
when
The determination on the condition precedent.
therefore, as I said, when we read it, we should not read it from the point of view of the center only. When we read the list 3, then we have to keep in mind that what was there in the mind of the framers. Now, if I may place that, just for the sake of argument, kindly notice that the written submission of
This law will cover not only electricity, but
पेज क्या था उसका? Lord, kindly have page 14, page 12 of the written submission of the solicitor. This is volume D. D for Delhi. Starts at 14, page 14. Lord, I would answer this in two ways. Lord. One is my angle of cooperative federalism, where the framers themselves left the space despite entry 33A. And the other answer to that would be, Lord, that this issue has been settled at least in 10 cases and has been consistently approved by our lordships, that the conflict has to be in fact, direct and in fact, in real terms, and not in possibilities. Now, before that note, I'll place this. Volume 2D, page 14, at the bottom, Govind Ballabh Pant. PDF page 20. PDF page 20. It is of great importance, not what they have said. And it is in the context of 33A, list 3. Sir, may I place it? Sir, all the 4 amendments, so and so and so, are interconnected and interlinked, and they must stand or fall together. According to the bill, development of industries where development under dominion control is declared by dominion law to be expedient in the public interest. Regulation and control of such industries, trade, commerce, whether or not within a province, in and production, supply, and distribution of products of such industries were to be included in list 1. That is, all these subjects were to be brought within the exclusive jurisdiction of the federal legislature and the federal government. Now that would have led to several other difficulties and complications. We all realize that so far as the development of industries where development under the dominion control is declared by dominion law to be expedient in public interest, and regulation and control of such industry should rest in the center. According to the entry already contained in the federal legislative list, development of industries where development under dominion control is declared by dominion law to be expedient in the public interest is already included, and there is no intention of making any change so far as that is concerned. But as proposed in this amendment, regulation and control of such industries should also be placed under the jurisdiction of the federal legislature. So far as the first two parts of this clause are concerned, they will stand as they are. But with respect to the rest, that is trade and commerce, whether or not within a province in and production, supply and distribution of products of such industries, it is proposed by the series of amendments to which I referred at the outset that these should be included in the concurrent list and changes should be made in other amendments. Now, why is it that they said? Now, this would have led to several other difficulties and complications. We all realize the development of industry is essential, but then both state and center should participate. Why should center say that we'll only deal with it and rest you can't touch it? Otherwise, what the consequences? Now, kindly have this again further note, last line of this, last 5-6 lines. So if these are made the exclusive charge of the center, then the provinces will not be free to discharge the duties and obligations which will necessarily devolve on them. In order to enable the provinces to play the part subject to the overriding powers that will now vest in the center, it is necessary to include these items in the concurrent list, and that is what I propose. Even now, when we have got the Essential Supplies Act, Center generally frames a few basic rules and leaves the rest to the provinces. Then in the end, last 4 lines, they require a very extensive network, and I think it is not possible for the center to manage these things without the active cooperation and support of the provinces. So I propose that the amendment to which I have referred to at the outset be accepted unanimously, and it was accepted. Importantly, Lord, if Lordship would go back to my written submission, Lord. Last paragraph, page 11, last paragraph, Lord. At least leave the middle paragraph. What we have to see, have you Lordship heard? Okay. Page 11 of my written submissions. Volume 1A. What we have to see is whether for inconsistency or repugnancy to operate, the field has to be actually occupied and not in the realm of possibilities. It is in this respect the theory accepted is that there has to be actual occupation in the field for inconsistency to occur. In other words, there has to be a regulatory order dealing with trade and commerce, supply and distribution. Under Section 18G of Article 254, repugnancy to occur for Article 254, repugnancy to occur. To come to a conclusion of repugnancy, the field occupied by both the laws has to be analyzed. Now, these are the cases which have approved the Tikaram G's principle. Lord, if I may submit with respect, Lord, for the purposes of repugnancy under 254, Lordships have never used this code unto itself argument, Lord, covering the entire. And that I would show from the latest Constitution Bench Note 2020. What your Lordships have accepted the principle that it has to be direct conflict in actual terms and not in the realm of possibilities. This is what the latest Constitution Bench also says, 2020. If I may give the reference one, 2020, volume 9 SCC.
Issuance of a notification.
And I'll come to your Lordship's judgment, the judgment which was there in Lordship's mind 2012, which my friend relied upon, Lord. That is wholly inapplicable. That was a case under Article 254, where the issue was whether the law which has been made by Parliament, signed by the president, assented by the president, has not been enforced. Now, what is enforcement of law? Conditional legislation, which is more of an administrative function. To make a regulation under 18G is not an administrative or executive function. You're creating a law. For instance, if executive function is so wide, then under Article 223, the power is vested in the executive to make the ordinance, which is equal to that of law. But will we call that executive function as per 162? It's not. These are the functions, which are lawmaking functions ascribed to the executive, which is co-equal to the law. And lordships have always said law made under the delegated legislation made under the law is part of the law. Now, therefore, I would submit with respect, this consistent case of acceptance of this Tikaram G with regard to inconsistency, which my friend says is obiter and was not needed. It's not correct, that is an additional argument given. Your lordships very often give more than one reason for justifying. So Tikaram Ji has given one reason and then he said that let's assume that to be correct and then see what is the position. And then it said that there has to be actual conflict.
What else?
Now, in Sriram Industries case, very interesting situation arose. I mean, the molasses part. There, the control order was issued under Section 18G, but was not applied to state of UP and Bihar. Now, therefore, the court said since it has not been applied, there is no actual controversy or conflict. Now, should we now say that even though it has not been applied, since there is 18G, therefore it covers the field, state cannot? The legislation was not to apply the order under Section 18G. Sriram Industries case. Now look at that's why I'm pointing out various situations where your lordship will have to look into the consequence of holding that there is a court by itself argument. An exception may be given to a state in respect of an order under 18G, yet we'll say no, it will apply, state doesn't have the power. So the aspect of total denudation which is there in entry 54 is not there in entry 52. That's what I am advocating. And when it comes to repugnancy under 254, we do not apply the principles of the conflict of entries. In case of conflict of entries, this may be the situation when the entire field is occupied. Therefore, there is nothing left. And lordship has seen the IDR Act, the earlier bench, how composite that act is. When everything has been taken away by the union, then nothing left for the state to do. Therefore, they said, you make a rule or you don't make a rule, makes no difference. It is in that context. And then, kindly see, as I said, there's a consistent line of authorities, at least 10 cases, where they have approved. And now at this stage, after 70 years, we are seeking reconsideration. In my opinion, with all due respect, Tikaram G is a case which is most well considered judgment, followed in other series. And minor tinkering here and there shouldn't take away from the value of that and worth of that judgment.
Anything else now, Mr. Dwivedi?
I'm sorry?
Anything else? Or
Yes. It is accepting this one small 1 minute.
Yes.
There is this judgment, I wanted to distinguish this case, 2012 volume 2 SCC 773, that the law was held to be made as soon as it is passed by Parliament and assented to by the President. Therefore, once the law is made, mainly because it has not been enforced, doesn't mean that the field is not occupied. That was the case which my friend had relied upon. What was the name? My friend will pronounce the name better than me.
Mara Prem Puri.
2012, volume 4. But that is a case where they interpreted Article 254 and found that the word used is law made or making of law. So making of law, the procedure prescribed is passing of the bill and signing by the president. The law is made. Once the law is made, the field is occupied. Enforcement is a mere executive act, makes no difference. But here it is different. But 18G is not an executive act of conditional legislation. Enforcement is nothing but conditional legislation and executive act. I think that would be. Due respect, but that case is therefore totally distinguishable.
Thanks.
I'm greatly obliged.
Thank you.
But my friend has covered most of the points, so my role is limited. First, let's get to entry 8 of list 2. And my submission is the end of the day. Lordship has to really decide whether the view taken by Justice Chagla is the better view or the view taken by Justice Fazal Ali is the better view.
That's
And
right.
that's the.
They're really the two competing views.
Exactly.
Justice Chagla.
So
you are in a way, Mr. Dwivedi was right that Chief Justice Chagla's view, obviously very weighty expression of authority, but that does not look at the legislative history, which Justice Fazal Ali has done.
Yes.
We really have to still weigh in the legislative history. As
I was about to say that 5F, the judgment starts at page 429, and the operative portion of this is at page 439. And as the Lordship says, my Lord, we are always hesitant to say Justice Chagla is wrong, but then I'd only say that, my Lord, Lordship has not considered the legislative history, and he has gone merely by the common parlance test. That's my submission. The Lordship now comes to page 439. Why should we do? View was partly accepted, partly reversed. And Lordship will just come to page 439. I'll just point out the paragraph. I won't read it in detail. And my submission is, apart from not considering legislative history or the use of the term in various excise acts, his Lordship's observation is contrary to the earlier paragraph their Lordships themselves cite in the Bombay High Court. So the Lordship has to compare 5F 439.
But you know, the learned Solicitor General, during the course of his submissions, also dealt with the legislative history per se.
Yes.
You know, particularly in that chapter 4, volume 4B, where he referred to the preamble to the Licensing Act of 1872.
Yes.
And his argument was that it basically deals with drunkenness. Then again, he relied upon Hansard. And the submission was that intoxicating liquor has always been understood, even in the legislative history, as a beverage which has been sold for consumption for human beings and has an intoxicating effect.
That's exactly what Justice Fazal Ali says. He says that under the common parlance test, intoxicating liquor is something of an intoxicating drink. something which is consumed by the human being.
Yes.
So, my lord, the importance of Justice Fazal Ali's judgment is he noticed this common parlance test. And I think where we are in error is we are trying to interpret a constitutional entry like a tariff entry in the Customs Act. We can't go by the common parlance test. If, as Mr. Dwivedi rightly pointed out, the Gannon-Duncalli test, if there is an expression, whether sale or intoxicating liquor, and that expression has not been defined in the Constitution, then one must see how the existing legislation has taken it. And then what Justice Fazal Ali does is he goes to the dictionary definition, he goes to the common understanding, and he says, no doubt, as per the common understanding, intoxicating liquor is something which you consume. But if you go to the provinces, Bengal, Madras, Uttar Pradesh, Punjab, all the provinces have taken intoxicating liquor to include denatured spirit also. That's what his lordship's view is. And so my first submission, my lord, to save time is Justice Chagla's observation at page 439 does not contain any discussion about the legislative history. His lordship says intoxicating liquor is a hard drink as opposed to a soft drink. It means only a beverage. Sure, take a lordship to that page now.
No, that's
Yes.
the same paragraph. The same paragraph. We've got just
That's
Chagla
all.
also.
Sorry, lordship is saying something more?
We read it in the first.
Yes, page 439. But if your lordship now sees Justice Fazal Ali's analysis, and I would request your lordship to permit me to see that thing, because at the end of the day, my lord, now your lordship is sitting in 9 judges. There is, in my humble submission, there is no need to reinvent the wheel and go back to square one. If Fazal Ali's view is acceptable, it has stood the test of time till 1990. The Union of India said it's a correct view. And I will show that the distinction made in synthetics and chemicals is completely not correct, Murad. They simply say Fazal Ali and the bench did not comprehend the possible uses of industrial alcohol. That can't be a ground to say the law is bad. So I'll just first go to Fazal Ali's judgment. Yes, Lordship will just come to volume 5 at page 1725.
That is always so.
Lord, it will be PDF page. Yes,
If you look at, for instance, the one of the key acts that Balsara relied upon was the Licensing Act of 1872.
Yes.
Now, if you just go to the compilation at volume 4B,
Yes.
just to sort of 4B,
4B, I'll just go to.
page 578.
Yes, I'll just go to it. 4B 578.
The page number of Fazal.
Stick in a volume.
This is.
Summer 4B 578. Just tracing it, Lordship must also see the Spirits Act of 1880 and then the subsequent Excise Acts. Because Lordship has to see what was the history after up to 1919, there was no such thing, Then after that only this problem came up. Now, if your Lordship kindly sees 578.
For the sale by retail of intoxicating liquors.
Yes.
And the regulation of public houses and other places in which intoxicating liquors are sold.
Yes.
And to make further provision in respect of the grant of new license for the sale of intoxicating liquors.
Yes.
And the better prevention of drunkenness.
Yes. That comes to public. No, I'm not. There's definitely a possible view to say that intoxicating liquor means only beverages for human consumption.
That's right.
But I'm saying that will drastically reduce the scope of intoxicating liquors, and on a ground level, it will be impossible to implement. I'm coming to that as a second stage. My first submission is, please see the observations of Fazal Ali, Justice Fazal Ali, sorry. Does it merit a reversal or an overruling? Kindly see his lordship's discussion. Now, kindly come to Justice Fazal Ali's discussion. Please come to para 38 at PDF page 1731. Para 38 minute. The Bombay Prohibition Act. Volume 5, page 1731. para 38. His Lordship extracts the definition of liquor in the Bombay Prohibition Act. Now please come to para 39. The Lordships come to para 39. Now the discussion starts after extracting the definition, which says liquor includes, Lordship will note includes, spirits of wine, methylated spirits. Just to pausing here, the UP definition says it refers to spirit, and spirit includes denatured spirit. That is in the UP Act. Now kindly come to para 39. The High Court has held that the word liquor ordinarily means a strong drink as opposed to a soft drink, but it must in any event be a beverage which is ordinarily drunk. Proceeding upon this view, the High Court has held that although the legislature may, while legislating under entry 31, prevent the consumption of non-intoxicating beverages and prevent the use of drinks of alcoholic liquids which are not normally consumed as drinks, it cannot prevent the legitimate use of alcoholic preparations which are not beverages, nor the use of medicinal toilet preparations containing alcohol. This view of the High Court was very strongly supported on one hand and equally challenged on the other, and I therefore proceed to deal with the question at some length. Then, my lord, his lordship takes para 41. 40 is the Oxford Dictionary. Now come to para 41, and then I'll take a lordship to para 44. Please come to 41. May I read, my lord? Thus, according to the dictionary, the word liquor may have a general meaning in the sense of a liquid, or it may have a special meaning, which is the third meaning assigned to it in the extract quoted above, that is, a drink or beverage produced by fermentation or distillation. The latter is undoubtedly the popular and most widely accepted meaning, and the basic idea of beverage seems rather prominently to run through the main provisions of various acts of this country as well as America and England relating to intoxicating liquor, to which our attention was drawn. But at the same time, on a reference to these very acts, it is difficult to hold that they deal exclusively with beverages and are not applicable to certain articles which are strictly speaking not beverages. A few instances may make the point clear. In the National Prohibition Act of America, 1919, they quoted, I'll just pause here, Lordship will just make a note. In Salesman, Lordship has got the National Prohibition Act 1919. In that page, in the middle, Lordship has seen that. There, just to pause, the National Prohibition Act was interpreted by the US Supreme Court. And I mentioned in my first argument that they said intoxicating liquor includes denatured spirit. That's what the US Supreme Court held. Now, my lord, please come. Please come to para 42. The Licensing Consolidated Act of England was an act relating to licenses for sale of intoxicating liquor. The definition of intoxicating liquor was as follows. Intoxicating liquor means, unless inconsistent with the context, spirits, wine, beer, port, etc., etc., and any fermented, distilled, or spirituous liquor which cannot, according to the in-law for the time being enforced, be legally sold without an excise license. The word spirits, as defined in the Spirits Act of 1880, as meaning spirits of any description and includes all liquors mixed with spirits and all mixtures, compounds, peppermint spirits, it was contended before us that the word spirits in the Spirits Act should not be imported in the Act of 1910, but in our view, for the purpose of understanding the definition of intoxicating liquors, the two acts should be read together. I do not suggest that the definition of liquor in the present act was borrowed from those acts, but I'm only trying to show that the word liquor is capable of being used in a wide sense. And Lordship knows legislative entry give widest interpretation. Now 44 is the most critical and most important paragraph. Coming now to the various definitions in the Indian Acts, I may refer in the first instance to the Bombay Abkari Act of 1878 as amended by the subsequent acts, where the definition is substantially the same as in the act with which we are concerned. In the Bengal Excise Act, liquor is said to mean liquid consisting or containing alcohol and includes spirit of wine, spirit, wine, tari pachwai, beer and substance, which the provincial government may declare to be liquor for the purpose of this act. In several other provincial acts, for example, Punjab Excise Act, UP Excise Act, liquor is used as meaning intoxicating liquor and as including all liquids consisting or containing alcohol. The definition of liquor in the Madras Abkari Act of 1876 is the same as the Bombay Act of 1878. Even if we exclude the English and American acts from our consideration, we find that all provincial acts of this country have consistently included liquids containing alcohol in the definition of liquor and intoxicating liquor. the framers of the Government of India Act 1935 could not have been entirely ignorant of the accepted sense in which the word liquor has been used in the various excise acts of our country, and accordingly, I consider the appropriate conclusion to be that the word liquor not only includes those alcoholic liquids which are generally used for beverage purposes and produce intoxication, but all liquids containing alcohol. It may be that the latter meaning is not the meaning attributed to the word liquor in common parlance, which is what exactly the union is attributing in common parlance, especially when the word is prefixed by the qualifying intoxicating. But in my opinion, having regard to the numerous statutory definitions of the word, such a meaning could not have been intended to be excluded from the scope of the term intoxicating liquor as used in entry 31 of list 2. Then there is another method of approaching the question which deserves consideration, remembering that the object of the Prohibition Act was not merely to levy excise duty, but also.
Mr. Datta, just let's dwell on this sentence.
Yes.
Even if we exclude
Yes.
the American and English acts from our consideration,
Yes.
we find that all the provincial acts of this country have consistently included liquids containing alcohol in the definition of liquor and intoxicating liquor.
Yes.
If we adopt this test, then the word intoxicating has no relevance at all. It has no meaning at all.
No, now I'll tell you why it is like that. Lordship will kindly see. We are now testing how does the state.
And then see what he says. Accordingly, I consider the appropriate conclusion to be that the word liquor covers not only alcoholic liquids, which are generally used for beverage purposes and produce intoxication, but also all liquids containing alcohol. So liquor may really refer to all liquids containing alcohol. But when the statutory language is, constitutional language is intoxicating liquor, then even though liquor per se may include all liquids containing alcohol, the moment the prefix intoxicating is added, we can't render that prefix a surplusage.
Correct. Now, Your Lordship,
if entry 8 was liquor, that is to say, possible view. But then we would be ignored. But if we apply that test, then why did the Constitution say intoxicating liquor? Liquor would be all liquor, all liquids containing alcohol.
Why add the adjective intoxicating? Why add the word intoxicating?
Intoxicating.
There are two answers to that. First is Justice Fazal Ali's explanation that if you go by the common parlance test, then intoxicating liquor means only liquor which can be consumed by human beings. That's the common parlance test. But he says, I'm interpreting a legislative entry, and the legislative practice in India, in British India, has consistently, because intoxicating liquor was there from the beginning, intoxicating liquor has always included all kinds of liquor, intoxicating other. That's a legislative practice. That's what Mr. Dwivedi highlighted Gannon Duncally's case. Intoxicating liquor has not been defined in the Constitution, but intoxicating liquor has been defined in a number of excise acts in the provinces. So when the framers of the Constitution made intoxicating liquor in the Government of India Act of 1935 and in the Constitution, they were using intoxicating liquors as a nomen juris. They were using it as a nomen juris, which meant this is a wide term. It's a legislative entry. It's not a tax tariff.
Which means all liquids containing liquid
alcohol. And so this is
all liquids containing alcohol.
Because that was a legislative practice. Every excise act, Bombay Abkari Act, Madras Abkari Act, UP, Bengal province, all say that intoxicating liquor includes everything, because the definition of liquor includes spirit, and spirit will include denatured spirit. So if you take a combination, intoxicating liquor always included. That's what Lordship sees. This is the first reason I'm giving. I'm giving the second reason. This is the first reason. It may be that the latter meaning is not the meaning attributed to it in common parlance, especially when prefixed by the qualifying word intoxicating. Exactly what your Lordship was asking. Why did they add intoxicating? But in my opinion, having regard to the numerous statutory definitions of that word, such a meaning could not have been intended to be excluded from the scope of the term intoxicating liquor. Intended by whom? By the framers of the Government of India Act and by the Constitution. So my first submission is, Justice Fazal Ali's decision is supported by, because it is considered dictionary definition, legislative practice, common parlance test, and on a comprehensive test of all these things, His Lordship says intoxicating liquor must include all. Now I tell your lordship why the second view will become unworkable in practice. If your lordship take the view which the union is advancing, that intoxicating means beverages, ready to make drinks.
No, Mr. Datta.
Sorry.
See, you are trying to say that because in British days,
In British India,
the states each had a act to deal with this subject, and they have taken liquor to contain alcohol, irrespective of whether it is potable or not.
Yes.
Intoxicating element is
no, the
not
word intoxicating liquor in all these excise acts included everything.
would mean
Yes, yes.
But if that is
Because-
how, and you are saying that this is because when we are interpreting a constitutional provision, we can't sort of blindly say common parlance test should apply, right?
Yes, yes,
Now, in the entry, so far as entry 8 is concerned,
yes.
and the constitutional entry here, we are talking about intoxicating
Until lordship, why? Until lordship, why?
because
But the point
your
is the
argument
whole
has
thing.
to be tested that way.
Correct, correct. I appreciate. The whole thing is we are confusing with intoxicating liquor, intoxicating drinks and beverages. Now, this entry, how does it operate? Lordship has to interpret an entry, keeping in mind the commercial realities. A distillery gets a liquor license. Lordship knows in my chart at page 12, it's either molasses or grain. Of course, it can be cashew, like in Feni in Goa, you make it out of cashew, but it's basically grain based or molasses based. Then you come to primary distillation, rectified spirit. Then you come to extra neutral alcohol. And then you either go to Indian made foreign liquor, that is rum, whiskey, gin, or you go to denatured spirit, which is for industrial purposes. Now, what happens is if your lordship sees intoxicating liquor, I'm saying please don't focus only on the two words. Please see further. That is to say, production, possession, transport, sale, distribution. All that means that the distillery which is manufacturing it makes everything. Because of the peculiar nature of our excise laws, whenever it was cleared for industrial consumption, right from the old Excise Acts, it had to be denatured. Today, UP, whom I represent, when the liquor which I know, if I have to clear 1,000 liters for industrial purposes, I have to pay a denaturing fee of 60 paise per liter. And in the presence of the liquor officer, I file DS6 or DL5, I fill that form and I pay the denaturing fee. Now, if you accept the union's argument that intoxicating means only ready-to-made beverages, then you are completely controlling only the IMFL manufacturers. Because the sugar industry doesn't make alcohol. Many sugar industries, they just make rectified spirits and sell it to whether it's the liquor manufacturers who are making whiskey, rum, etc. Few sugar industries do start to finish. We stop at extra neutral alcohol or rectified spirit. From there, the lorry goes to the IMFL manufacturers. You pay state excise duty, you clear it, and goes. You make denatured spirit, you close. Now, if we accept the interpretation, let us visualize that intoxicating liquor means only to make ready-to-made beverages. Then who controls the distilleries? Will the union step in? Because up to extra neutral alcohol, it is intoxicating. And Lordship will kindly see one thing. Let's appreciate one important point. You don't denature alcohol to make it fit for industrial consumption. No. You denature it to make it unfit for human consumption. The denaturing is not to make it as a raw material for paint, varnish, polish, perfume, etc. Because it can be diverted, state loses excise duty because Lordship sees for denaturing 60 paise per liter. If it goes for IMFL, 18%. Duty is huge. In some cases, 300%. Duties are huge. So please appreciate this entire gamut from manufacture to distribution is all ENA. Is all extra neutral alcohol. The state controls everything. And you can't have a vivisection of alcohol meant for human consumption and intoxicating liquor meant for this. Sorry, that is not the case. And one more thing I want to submission is that if your lordship gives that interpretation, it will lead to a serious breakdown that the sugar industry which is making ENA, it is not making a soft drink, a hot drink as just Chagla calls it, or a ready-to-eat beverages. And solicitor said it should be intoxicating drink as in Article 47. With great respect, no. It will be chaos. So, my lord, and that is why what happens is in the amendment to the Industrial Development Act, they say the line of demarcation is the point of removal. Please read the statement of objects and reasons. They're very well drafted. They realize synthetics and chemicals has created created hardship. And therefore they say Bihar distilleries gives a better formula and Parliament decides to accept the Bihar formula. They say, let's go up to the stage of removal. Up to the stage of removal, it is state control. Whatever is denatured is central control, central tax. Lord, let me just see Parat, sorry.
Intoxicated?
No, Lord, in fact, in a lighter vein, I was just remembered Justice Krishna's thing of intoxicating. There are 4 stages. I don't know if Lordship has seen that judgment of P.N. Kaushal.
In Kaushal.
Yes, yes. That is, what is it? I'll tell you, I made a note of it. 4 stages are jocose, bellicose, lachrymose, and comatose. So when you start consuming liquor first, jocose is jolly, you're playful. Then bellicose, you become aggressive or belligerent. Then lachrymose, you start weeping, you become tearful. And finally comatose, you go into a deep sleep. That's P.N. Kaushal's explanatory intoxicant. This in a lighter vein. So, my lord, I just submit that I would request your lordship to accept Balsara. For one reason, A, it is well reasoned. B, it follows the Gannon-Dunkley came later, but it synchronizes the Gannon-Dunkley test. Words not defined in the Constitution, but which have been given a legislative meaning for several decades, must be treated as nomen juris. So it is not the common parlance test, but it's the legislative understanding of the word which is important. Second reason is,
One second.
sorry. Yes, this. So second reason is it works in reality. If you accept the view that intoxicating liquor includes everything, then the existing system of distilleries manufacturing everything and only denaturing, when does it become less intoxicating? When it's denatured, that's all. Nobody starts making denatured spirit. As I said, denaturing is an offspring, is a child of intoxicating liquor. One baby is denatured, the majority is the. So the second reason is it works in practicality. If a lordship takes the union view, it could lead to serious problems. And only IMFL units will come under state control. Thirdly, and neither the attorney nor solicitors answered this point, in para 41 of synthetics, Mr. Parasaram, who was the then Attorney General, makes a solemn statement that Balsara need not be disturbed. It has stood the test for 38 years. And it is not a statement made in an SLP admission. It's a statement made by the highest law officer, keeping in mind the principle of consistency. And till today, nobody from the other side has said why we are decided to depart from the Balsara view.
What the solicitor was saying was that Just because you take a particular stand at a given moment or a position, you can definitely take another position at a later point. That is what he was trying to say. And he said that I will cite 4 judgments in support of my, this proposition.
True. No, the point is exactly. Now, I'm not saying that there's an estoppel. Like I think Oliver Wendell Holmes says, if I need not be consistently incorrect. So I'm not saying no. Consistency need not always be a virtue. My humble submission is this issue came straight front before the 7 judges bench. The Attorney General, Mr. Parasaran, at that time says, we don't want to disturb Balsara. We also agree that entry 8 can include denatured spirit. That's in para 41. So the burden is on the union to show that our acceptance that time was faulty. For A, B, C, D reasons, we choose to take a different view now, and that is not forthcoming. The principle is, yes, I can always change my view, but you must justify to this bench why the statement made by Mr. Parasaran is wrong, and now you have to completely.
But Balsara is in the context of prohibition only.
No, Balsara is in the context of interpreting entry 31 is equal to entry 8.
In what context? Prohibition.
Doesn't matter.
Bombay Prohibition Act.
Yes, but Balsara has been followed for 38 years in a number of liquor cases. Consistent it, Lord, except this complete somersault, some complete change in synthetics and chemicals for 38 years. Lord Lordship knows in every high court there are numerous cases on prohibition. Like every time there is some liquor license, there is case after case on prohibition. Balsara was followed consistently. And please see what is the reason of synthetics. Please see para 74 for a minute. Please indulge me in 74. Is this the way, with great respect, are we going to reject a proposition of Mr. Balsara? I'm saying this thing, even assuming Balsara could be today a Lordship can take a better view. A different view. I'm saying, is it necessary? If one view has stood the test of time, accepted by the union, then unless there are overwhelming, compelling reasons to change it, I'm saying don't disturb it. Now, please see para.
But then synthetics has also stood the time now for 35 years minus this reference.
No, but the point is, as far as synthetics and chemicals is concerned, it in fact, far from settling the law, it unsettled the law, and you had different cases. You had Bihar, VAM1 on one side, other case on one side, Modi Sugar, Deccan Abkari on the other side. All that is noticed in the Law Commission report. The Law Commission report notes that too. Actually, I prepared a table of cases following the synthetic view, cases opposed to the synthetic view. And if synthetics was followed, where was the need to amend the law retrospectively? The Law Commission notes that because of synthetics, a lot of confusion has taken place and we have to set right the law. And then they make a clear demarcation in para 3 of the para 3 of the statement objects and reasons that it is now necessary to demarcate the jurisdiction of union and states. That's paragraph 3 of the statement objects and reasons. We want to make a clear-cut fence. What is the union's territory? What is the state's territory? And what is the fence? The time of removal. The time of removal. When you remove denatured alcohol, Parliament, GST. When you remove for IMFL, state excise, state laws. That's as simple as that. What synthetic says is industrial alcohol is equal to ethyl alcohol. Lordship, can you see? Synthetics may have stood the test of time, but the fundamental error is they say rectified spirit is industrial, ethyl alcohol is then they say alcohol means fit for human consumption. There are a series of errors in synthetics and chemicals which led to this 9-judge bench. And that is also well brought out in the referral order of Lalta Prasad. So, but Balsara, nobody has said Balsara was wrong. Compared to synthetics, Balsara didn't lead to a divergent views. One pro-Balsara view, one anti, no. So I'm just saying that the analogy of Balsara and synthetics may be slightly. Now just see. Tikaram.
to say, it's a composite industry. Industry will make ENA. Partly it will be converted into liquor, partly it will be denatured. So who controls it?
Majority converted to liquor, and only part is denatured by adding the denaturing in the distillery itself as per the denaturing rules. Lordship will kindly see every state has got denaturing rules, has got a denatured table. If you want to use for paint and varnish, add this denaturant. If you want to use for this, add this denaturant. And I'll show you the exercise manual of the Kerala in my written submission last, that all the liquor and denatured is one small corner. So to your Lordship's answer, it is composite. Now, if you accept the state that entry 8 is only for intoxicating beverages, then it will not cover a distillery, it will only cover an IMFL manufacturer. The sugar is the industry which typically makes molasses, and then it's a good byproduct for them, it's a good source of revenue to convert molasses.
In which event, who will control that industry?
Who will control that industry? It was working perfectly well till synthetics came along.
Commander.
In a situation like this, suppose it's a composite industry. Partly the ENA is sold for for IMFL, and part of it is of course denatured. In such a case, it's a composite industry. Who controls it then? What happens on the ground?
owner controls so far as regulatory control is concerned.
Regulatory control.
Regulatory control is concerned, my lord. So far as it is central government's part, the central law will apply. But that happens. My lord, local laws applies. There are central laws apply. My lord, in every case this happens.
You can't have two excise officers in the same factory.
So you'll have a duality of officers.
Two excise officers.
What happens actually on the ground?
On the ground, my lord. On the ground also, my lord, in all factories, all industries, there is a dual control.
No.
For
And with great respect, utmost respect.
I never go by the innocence on the face.
On this,
No,
we
take for example the
we can
pharmacy.
on this, we'll tell the solicitor that you are innocent.
No. Not pharmacy. My lord,
You have some of the industry representatives here.
Yes.
What happens? Who controls? I mean, what is the ground situation? Because today synthetics holds the field. Now,
take for example, my lord. If there is someone, my lord.
Is anybody here? Mr. Praveen Kumar?
But I've got the entire excise
But
manual.
otherwise, my lord, kindly, please, only,
Sorry.
if you don't mind. Lord, pharmacy, for example. But there is bound to be state laws, my lord, which are applicable to a pharmaceutical company situated in a state. It would be governed by those state laws. So far as central legislations are concerned, they are also governed, my lord, governing the pharmaceutical industry. But that is the reason why for a company having more than one particular turnover, you are supposed to have a company secretary who is trained, my lord, which law of the state is to be complied with, which law of the center is to be complied with. But that can never be a ground for assisting your lordships, my lord, on the question of constitutional interpretation. Every industry, my lord, take any textile industry, there would be, my lord, there are bound to be state laws and bound to be central laws, and both are to be complied with.
But actually, in such a situation, the central laws are also enforced by the state officials.
That is, my lord, delegated legislature. I am not on that. So that can still be done.
No, apart from the delegated legislation, because our constitution contains that provision, right? That if it's a central law, the implementation of the central law is also entrusted in the states to the state officials.
Certainly.
But the center is a very small complement of officers.
No, correct. No. We can't have, suppose for example,
So
IDR.
Industrial Disputes Act. It's enforced by the state officers.
Correct.
In the states.
Except, my lord, possibly taxation, excise, etc. Few, my lord, subjects, all are implemented by the officials of the state government. They implement respective or my lord, whichever is applicable, central law or state law, as the case may be.
Article 73. You see, Article 73, the proviso says, provided union executive power, provided, just see 73(1), subject to the provisions of this constitution, the executive power of the union shall extend, A, to the matters with respect to which Parliament has power to make laws, and to the exercise of such rights, authority, and jurisdiction as exercisable by the Government of India. Now, provided that the executive power referred to in subclause A shall not, save as expressly provided in this constitution or in any law made by Parliament, extend in any state to matters with respect to which the legislature of the state has also power to make laws. That's why, and you know, as you rightly said, for say income tax, the Income Tax Act provides for a whole administrative machinery.
Your Lordship, see 256, Article 256.
Just
Datar is trying to
save
suggest
time.
that, you know, there'll be, just one second.
1 minute, just to save time, we've got all the excise manuals of all the states. There is not a single excise manual which has got a role for a central excise officer to play a part. No. We pay the duty. When it goes for denaturing, we put the excise duty challan and we pay excise duty and remit it to under this.
Because of the present regime,
Yeah,
my lord,
heading B below it,
obviously
goes to
because of the
central
present
treasury.
regime.
State, it goes to state treasury. Excise, all my colleagues are here. In all our distilleries, in all the IMFL plants, it's only the state officer who's present.
Because of this law, my lord, because your law is being settled by a
The amendment says, the objective reason says, the new law, the state has everything till the time of removal. What is the time of removal?
Can I
Removal of
answer the
denatured
question?
spirit.
You rightly, I mean,
No, I'm saying
at a right point.
I'll finish by 4 others also. Sorry.
Article 256. Obligation of states and the union. The executive power of every state shall be exercised so as to ensure compliance with the laws made by the parliament and any existing laws which apply in that state, and the executive power of the union, my lord, that is corresponding provision. My lord, for example, there is a law made under entry 52 that we, the center, the parliament, wish to regulate coffee industry in a particular way. And the law provides that this would be the formats prepared by the state authorities. This would be the reports to be filed, returns to be filed, prepared by the state authorities. That can be done. Right now, the question is whether that power is traceable to 52 or not. How, Lord, the industry is run in an era or a regime where your lordships are yet to take the call can never be a ground to say that that call may not be taken because we are running it right now in this particular fashion. If your lordships takes the view, this is subject to 52, read with 33, with or without 33, then my lord, constitution will take care of itself. But to say that right now there is no system and only state is implementing is no legal answer to a constitutional question.
Lord, I've got a legal answer to that. Lord,
only a minute. Let me complete.
No, finish.
Yes.
Lord, supposed to give us some time next Tuesday, my Lord, we can't finish.
No, that's Lord, one more thing.
ENA, even at the stage of ENA, it is alcohol basically.
Yes.
No, one more thing. Lord, entry 52 says control of the industries. No, control may not be restricted to the control my learned friend is expressing himself to be. That's my officer is there, state's officer is there. That's not the control. Control would mean control by law made by the parliament. The law may say that we would exercise control, we would regulate, we would examine A, B, C, D through the officials as may be appointed by us. And those officers can be state officials also.
No, Solicitor, we can ignore all this. Who actually manages this today, that's, we are not concerned with that. But question is, what is the meaning of intoxicating liquor? Because take a case of a sugar industry. What will be manufactured will be ENA, which is alcohol, which is intoxicating liquor.
No, it is capable, it can be abused as an intoxicating liquor.
No, ENA.
Not ENA.
But ENA.
Whether it is
ENA diluted country liquor.
whether grain is used or whether any other fruit is used or sugarcane is used. It is ENA only. And ENA is alcohol
For the
intoxicating
purpose
liquor.
of
You dilute ENA with water, it becomes.
It becomes country liquor.
Manoj, that's correct, Manoj, but that's not the way in which entry 8 uses it. Entry 8 uses it as
No,
something which can be consumed as it is.
So, Mr. Solicitor, ENA, who will regulate ENA? ENA is not denatured spirit.
It's not
It is an
unnecessary.
intoxicating liquor.
Kindly see, the law is clear.
It's not denatured spirit.
My lord, they
Because
have
it is-
confused denatured spirit, ENA, this, that. The law is very clear, potable and non-potable. If it is non-potable, it is state, it is center. If it is potable, it is state. And potable would,
This is going far away.
look, if Mr. Gupta also rarely, my lord, does this. I really have a strong case. Well, this is one more factor in my favor.
Yeah, what is Mr. Gupta saying? Just in 10 seconds.
ENA is a raw material for IMFL.
No. Raw material is either
No,
sugar
it is the
cane,
basic wrong.
etc. You don't get.
This is a fundamental misunderstanding.
But how do you get ethanol? Well, how do you get ENA?
ENA, my lord, is cleared.
No, I'll tell you.
It's cleared as an excisable product.
Lord, when it's denatured, it goes to GST entry 2207. If it is not denatured, it is ethyl alcohol coming under ENA, coming under state law. I put GST entry also there. The GST council says
Only a minute.
So-
Only a minute. But let us not be confused on this. For every kind of alcohol, the raw material is either sugarcane, grain, grapes, etc., molasses, etc.
Correct.
Thereafter, my lord, what you get is spirit. It can be denatured, it can be any other name. And thereafter, by distillation, you get potable alcohol.
No.
So, EN.
Sorry. No, sorry, sir, because you actually
You
please
should be sorry, but not for this.
Yes. No. So fundamentally wrong. Fundamentally.
My lord, raw material means from where you get it. You don't, my lord, is it available? Is the ENA available, my lord, in a natural form from where I can get it? And I can manufacture, say, whiskey or scotch or some whatever, my lord. No, you have to make ENA. And then that is used as a raw material for the purpose, but for the purpose of making.
But ENA is intoxicating liquor. There's no dispute on that.
No
It's alcohol.
dispute.
Yeah, alcohol.
Intoxicating liquor, but my lord, not for consumption.
Right?
Not potable. You have to do something.
No, we want to understand one thing. ENA is alcohol. So it can be intoxicating liquor.
My lord, when
ENA is
when we
95%
go to,
alcohol.
when, my lord,
Sorry?
my lord, let us
95%
not,
alcohol is ENA.
let us not, my lord, give meaning to a constitutional provision which is unnatural. My lord, when the constitution says, my lord, intoxicating liquor for human consumption mean something which is as it is capable of being consumed.
That's a
That's my lord, as simple as that. Not that it can be converted into something which is, my lord, can I go and say that give me 1 liter of ENA because I want to consume it after adding something into it? I cannot. It's as simple as that.
So therefore, according to you, it will not cover ENA, according to you. Is that sufficient?
Yes, it cannot. It cannot.
My lord, I'll make my submission. Yes. My lord, my humble submission is entry 8 covers ENA. Parliament has no role to play. My lord, at one very serious issue comes here. There are totally 168 general entries. 168. 82 entries are with the central government, Parliament. 81 entries plus 97. 82 entries. There are 46 entries in the concurrent list. There are only 40 general entries in the
Only
state
a
list.
minute. Before you start, give me 2 more minutes. No, page 53 of my written submission. No, just, it is already filed. Please see, my lord, from where the process starts. It's really unfortunate, my lord, that the industry is saying that
Okay,
what
just
is
one
wrong.
second, and we'll come back to you in a moment. So then that is the solicitor's done.
Yes.
Mr. Solicitor, which page are you
Page
taking us to?
53, my lord, volume 2D.
Starts from the.
Kindly go a page before, my lord, kindly go a page before. Lord, alcohol is concerned, the following details are relevant. Alcohol is derived through a distillation process where carbohydrate, that is sugar or starch, is fermented and then distilled to extract alcohol. There is no other, I'm sorry. Then alcohol can be made from any feedstock which has high content of carbohydrates such as sugarcane, rice, maize, potato, beetroot, etc. In India, alcohol is predominantly made from sugarcane juice, molasses, a byproduct of sugar production, broken rice, damage of food grains, and maize. Major types of alcohols are given below. The rectified spirit. The rectified spirit generated after distillation out of those raw materials, having minimum 95% ethanol content is used only for industrial purpose. It is used for industrial purposes such as users as solvent in paints, industrial chemicals, etc. Then extra neutral alcohol, ENA. This neutral spirit having minimum 96% ethanol content is made by further purifying the rectified spirit. This is used both for potable alcohol and industrial purposes.
Mr. Solicitor, just
Only a minute more.
No difficulty. Otherwise I'll forget the question.
I'm sorry.
Now, extra neutral alcohol, ENA. You say that this is neutral spirit having a minimum of 96% ethanol content, which you produce after further purifying rectified spirit. Then you say this is used both for potable alcohol and industrial purposes.
For
right?
making potable, no? It should be for making. It comes
Used for making, right?
Yes.
Now, in that case, at the point when ENA is cleared, is the stage of removal takes place, and it is removed for the purpose of the manufacture of potable alcohol.
IMFL.
If you don't mind.
IMFL, that is. Right? It is being removed at the stage of removal. Why is it being removed? It is being removed for use in the manufacture of IMFL.
Potable, yes.
Will not that fall within the domain of the state? If it is removed at the point of removal for industry purposes, we want you to respond to it. We want clarity on it. At the point of removal, if it is being removed for industrial purposes, certainly then it doesn't fall under entry 8. But
not for the simple reason that extra neutral.
According to
Data, sir.
Sorry, my lord.
Not
we are getting bellicose.
It's indecent. Apart from anything else, it's indecent. You are not.
Well,
You
Mr.
seem
Datar
to be not
won't do anything
practicing
like
here.
that, you know.
No, Mr. Datar would never do that. I'm saying him. I'm telling him.
Reply to so many points.
Whenever I argue, that's what he does. So I said it's indecent.
Not Mr. Datar.
No. He would never do it. He would never do it. No, he seems to be not practicing here. Just as a younger brother, I'm telling him not to do this. It's anywhere, before anyone.
Mr. Just say sorry to the solicitor.
No, it's not in an anger or something.
Right.
This happened fifth time, so
Right.
sixth time I just couldn't resist.
He's apologized.
No, that's okay. That's over. Now, my lord, this is, my lord, a product which I purchase. If I am the IMFL manufacturer, I purchase that product. And thereafter, my lord, the third category of alcohol is absolute ethanol.
See,
Also,
just 1 second. But the person. Solicitor, your point therefore appears to be that it is only IMFL which falls within the purview of entry 8. Because that is the only thing which classifies as potable.
potable alcohol which can be consumed as.
Sure on that. There's a little bit of we are not sure on that, because at the stage when ENA is removed for the purpose, ENA is capable of being used both for potable liquor, right?
For
Now,
making
what happens if you have, say, somebody whose business is dealing in ENA is removing it for the purpose of potable alcohol, namely for IMFL. Then can you say that then it will not fall within the purview of entry 8?
Yes, may I say the
In
difference?
your submission, it will not fall in the stage of entry 8 until a IMFL is manufactured. I'm not sure that's the correct position.
May I show the difference according to?
Yes.
No, just
Lord,
one second.
Yes.
So is it your case that ENA will not be covered by entry 8 and only IMFL is covered by entry 8? Is it your case
Yes.
specifically?
Yes. Lord, number 2, why it is? ENA can be used as it is for other purposes like, my lord, industrial purposes, etc. ENA cannot be used as it is as a potable alcohol. And if you have to undertake some activity or some process to make it potable, that is the distinction. ENA as it is used for, my lord, polish industry, etc., etc. My lord, there are several industrial uses. In this context, please see page 53, the chart. Page 53, my lord, for my satisfaction. Have a look at page 53. This is how it happens.
Flow chart.
Lord, molasses, sugar syrup or grains. This is the raw material. I'm very clear about it. For any process which is subsequent, this is the raw material. Then preparation, that is adding water and enzymes for fermentation plus grinding in case of grains. Then, my lord, comes fermentation. My lord Justice Oak has the...
Yes.
Then comes fermentation, that is time taken up to 72 hours. Then comes distillation, means to remove water and impurities to get pure alcohol. Then, my lord, we get either of these three things, my lord, depending upon the nature. Absolute alcohol, rectified spirit, only to be used for industrial purposes such as paint, chemicals, etc. Then upon further purification of the RS, it becomes extra neutral alcohol.
Now, we got it. Now, for the purpose of my question, are you all on the same page, page 53 of the chart?
But
now, just one second. Look at the right-hand side of your chart, and the three, upon further purification of rectified spirit, ENA, extra neutral alcohol, minimum 96% ethanol, BV. Now, there are two branches. One, industrial use depending upon market conditions or alcoholic beverage. So your contention is that until it becomes an alcoholic beverage, even at the anterior stage, it falls outside the purview of...
Not the middle box wrong. Rectified spirit only for purposes is fundamentally wrong. The middle box. Rectified spirit only for industrial purpose. That is wrong. Because rectified spirit is primary distillation. It can be both. In the old days, rectified spirit was used for country liquor at 26% dilution, 32% dilution. Now with advanced technology, it is in ENA. So it is distillation, RS, ENA. But RS for industrial purpose is fundamentally wrong, which is the same error which synthetics made.
No. Synthetic doesn't go into this.
No. Lord, synthetic says RS is equal to industrial alcohol.
Kindly, my lord.
This box is wrong.
My lord, rectified spirit is used. It's very, very hazardous. My lord, this is what the huge tragedies come. Rectified spirit can be used, but its use is a wrong word. Abused. My lord, there are certain elements, my lord, which are mixed.
Sure.
And my lord, when I say depending upon market conditions, my lord, sometimes the requirement of industrial use Lord, only two more minutes. Lord, industrial use, when I say depending upon market conditions, some, Lord, depending upon the market condition, from the ENA, they make more, ENA, if the demand is more. Otherwise, it goes into making of Lord, on the basis of use, Lord, your Lordships may not, Lord, define the term. The definition is, it can be capable of being converted into many things, Lord. Well, rectified spirit is used in making not just country liquor, the hooch also, my lord, the hooch
All
tragedy.
right, we now got yes, Mr. Datar, what do you have to say?
I'll gather to.
And my lord, my apologies to my friend, my lord, but I got irritated on the sixth occasion, my lord. That's all.
All right.
Lord, quickly, my lord. So, Lordship, I recommend Balsara should be accepted. And para 74 and 77 of synthetics, where they distinguish Balsara on the ground that they did not comprehend industrial use, is not a ground to overturn Balsara. Balsara, consistently, the application of Balsara had created certainty. Synthetics creates uncertainty. I would pray that your Lordship restores the Balsara provision. Secondly, my lord, my submission is intoxicating liquor is an exclusive state subject, not subject to anything. And I want not subject to parliament. The word subject to is not there. So, my lord, ultimately there are 40 entries in the state list today.
We'll just take it down. Because we are,
Go for 5 minutes.
yes, certainly.
40 entries in the state list. And out of the 40 entries, 13 entries are subject to list 1 or list 3. So virtually out of 168 legislative entries throughout, general entries, I'm not including tax. Out of 168 general entries, there are only 40 in the state list. And out of 40, 13 are subject to either list 1 or list 3. So only 27 are left to the states. So my humble submission is, entry 8 should be interpreted to preserve the state's legislative competence in its widest amplitude. When the attorney, when the solicitor, I was just thinking to myself, just a thought came to my mind.
According to you, admittedly, even according to your position, would be outside the field of entry 8.
Outside entry 8, once, not only according to me, according to parliaments after the amendment, once the liquor is removed from my factory, then it comes under parliamentary control. Once it is purchased by the paint factory for making a paint or purchased by a perfume company or by somebody else, I have no control over it. UP government has no control over it. But I'm just giving, suppose for example, I decide, so as a legislative policy, I want to maximize my revenue. I'll say we are not allowing denaturing. Everything should be cleared for IMFL. I can do that. Take Bihar, they'll say no clearing for IMFL, only for industrial purpose because there's prohibition. So right up to denaturing is the state subject. And let us not dilute that is my humble request. I'll come to the next point on Tikaram G. I just wanted to say that in the para 32 observation, basically Tikaram G UP Sugarcane Act was to be ultra virus, IDR Act and Essential Commodities Act. In para 32, they say even assuming, if your lordship sees my submission, written submission, which I
You made the point, even assuming.
Yes, even assuming. I'm saying it is not obiter. It is Article 141. What Justice Bhagwati is saying is, even assuming 18G is there, unless there is a notified order, the state's power is not taken away. It is not obiter. It is a ratio decidendi. Obiter is something which doesn't fall for consideration. And just it's a passing observation. Now, further, Tikaram G has been accepted to be correct law in Belson, 5 judges, and 3 other cases. That's in my written submission. I've given those 4 cases. So Tikaram G's observation that unless there's a notified order, 18G doesn't operate is Article 141, good law, not obiter. Now just see the Industrial Disputes Act in the IDR Act for a minute and I'll just close my submissions. My lord, in my written submissions, if your lordship takes my written submissions.
Mr. Datar, in case you require 5 or 10 minutes more, please don't feel rushed.
Other friends also. I'll take 5 minutes and I'll give to them because
since we are concluding, or if you want to come tomorrow at about 3 o'clock, we can wrap up.
We'll finish 5-10 minutes more. My lord, what I can suggest, lordship, tomorrow at 3 o'clock, the others can reply, my lord.
Not there tomorrow, so let's conclude today. We'll conclude today. We'll go a little longer also. We'll go a little longer, but all of you don't feel rushed for time. We'll go a little longer, no difficulty.
Lordship wants to take a break and come back also, we'll wait
We'll
here.
do that. Just use a comfort break and come back.
Yeah.
There's an Eid celebration by the bar, but the bar can wait for another 10 minutes
Yes.
for us. All right.
They definitely know I'll call them a lot. Each celebration. Yes. Right away. So, my lord, now what I did was I analyzed this Industrial Development Regulation Act. Now the argument was that 18G per se creates an occupied field. If your lordship now sees my written submission 1O, very interesting. Of all the sections, every section except one section, every section says central government by notified order, by instruction, by notification in official gazette, by rules. Section 20 is the only section which says that on management and control, state law will not operate. Section 20 is the only which your lordship mentioned last time. Once section 20 says that management and control is by IDR Act, all state laws get repugnant. But every other provision, your lordship just see my written submissions. At page 1, it's now 1O. Just take it. Please come to, I made an analysis. Question, Lord, what I've done is I've answered the questions individually. And lordship will just come to question 3, 18G. Now, may I request your lordship to see 18G for a minute, please? 18G for lordship, can see the Bare Act. We all have read 18G1, nobody has read 18G2. Lordship is what 18G1, 18G1. Lordship has seen one number of times, I won't read it again, by notified order. Please see 18G2. Without prejudice to the generality of the powers conferred by subsection 1, a notified order may provide for A to H. Now, my humble submission is, today there is no notified order at all. So our submission is the whole field is open to states. Tomorrow, my lord, hypothetically, the notified order may cover only A, D, F.
Right.
My submission then is, whatever is not covered will be open to the state legislature. Because the notified order has got a scope of covering a territory of A to H. If Parliament chooses to cover only A, B, C and doesn't touch the others, technically nothing wrong.
Except that 18(1)
Yes.
expressly confers the power on the central government.
Exactly.
Now, where do the states get their power?
No, if the central government doesn't confer it, because entry 18G is...
That's a little far-fetched.
No, I tell lordship why.
The central government, before it decides whether to exercise or not exercise the power, has to be satisfied about the conditions precedent which are spelled out in subsection 1. If the central government comes to the conclusion that the conditions precedent are not satisfied and therefore does not exercise the power, the state can't say that, well, I'm taking a different view of the conditions precedent and I'm exercising the power because the central government has not exercised.
Your lordship is right. I will not make such an argument. What I wanted to see, what Tikaram G said.
That's right.
Only to the
Says the states can exercise power only under entry 33 of list 3.
Exactly.
Because in respect of a controlled industry.
Exactly.
Except for the fact that to the extent to which the field under entry 33 is covered by the IDRA,
yes.
Because now we are very clear that 18G is an exercise of the legislative domain under entry 33.
Same language is
right?
used here.
Therefore, once 18G has occupied the field, then the states cannot say that I will bring about other legislation or exercise power under 18G because the central government has not exercised.
No, I don't say that. 18G is a central act. There's no question of
Obviously.
exercising powers in the state.
So you are saying that the state can then enact a law.
No, I'm saying that entry 33 is concurrent list.
Right.
So trade, commerce, production, supply, distribution is both parliament and state.
Right.
Entry G, 18G, the power to prescribe except production, they don't touch production. All other things, the state can make a notified order. The argument of the union is, once 18G is there, that is enough. According to me, because lordship will kindly see, when parliament makes a law, it can either make a law fully, which is fully operational per se, like the Income Tax Act or central like GST, it is fully operational, nothing is required. It can make a law which has to be implemented through a notification, through a notified order, subject to rules. So in that case, the law is still not there. The law, only the power is there, but it's not exercised. I am putting for the.
But except for the fact, conceptually,
yes,
a failure, or let me not use the word failure, the absence of a notified order by the central government may be an indicator that the central government as a delegate of parliament does not consider it expedient to regulate that particular aspect.
Yes. In fact, I was going to tell you
At this stage.
Yeah. No, in fact, Lordship will
In which case can the state say that, well, because this falls in a concurrent list subject, though Parliament's delegate has come to the conclusion that it is not expedient to regulate for a variety of reasons, the state will still regulate. That may be a little far-fetched.
No, what I'm submitting is entry 33 must be read with entry 26 and 27. Supply distribution is open to the state legislature subject to entry 33. What happens is once a notified order comes, it becomes an occupied field in entry 33 and it's a no-go zone for the state.
Until the stage of a notified order, there is no occupied field.
There is no occupied field.
The doctrine of occupied field is not dependent on the administrative exercise of power.
No, I'm only submitting.
It is postulated on the existence of a legislative instrument.
I'm submitting, my lord, the doctrine of occupied field should not be mixed up with the doctrine of occupiable field. Occupied field means Parliament has occupied that field.
It has occupied the field by legislating, not by providing for an administrative order under the
No, I'm just leaving Lordship interpretation.
Conceptually, it makes very difficult.
No, please see conceptually. Please see conceptually. Entry section 20, they clear bar of the states. Now there are many cases, management takeover, etc. is there. Many things of regulation, other provisions are there. We are only concerned with 18G. Yes. Only 18G. I am submitting the entry 33 will prevail over the state's power under entry 25 or 26 of list 2. Lordship will just take entry 25 of list 2, which is subject to entry 33. State list.
26, yeah, 26, 27.
Yeah, 26, 27. So trade commerce within the state, production supply within, of course, within the state, will be subject to entry 33. So I'm only submitting that if entry 33 has not been exercised by Parliament by issuing a notified order under 18G, my powers under entry 26 and 27 are there.
So long as a notified order is not issued.
Not there, because what I'm submitting is in a law made by Parliament must necessarily mean a law made by, how does a Parliament make a law? It may make a law per se, or it may make a law which is implemented through a notification. If the notification is not there, no. In taxing laws, we say a lot. If the computation provision is not there, there is no charging provision. So if there is no prescribed rate, there is no duty. So I am only submitting your Lordship. Entry 18G, that's why Tikaram G, I use the word occupiable field.
So Mr. Datta, is it your contention that today, because there is no notification, state can legislate on subjects touching 18G? Can there be a state legislation dealing with the aspects covered by 18G today?
Yes, my submission is take for example milk products. Take entry 27.
There could be a state legislation touching the aspects covered by 18G.
Yes, scheduled industry it can be. So please take the scheduled industry, Malone.
So what you are effectively arguing is this, that if there is no notification under section 18G, the subject falls under 26 and 27 of the.
I'm not saying, no, that will be a wrong argument. I'm not making that argument. See, Lordship will kindly see, the Industry Development Regulation Act covers 39 industries under the scheduled industry. The schedule covers 39 types of industries. Now, the center can occupy that field by issuing a notified order under 18G. It can control supply, distribution, trade, commerce. No problem on that. Today, center has not done it at all.
But your argument postulates that the occupation of the field ensures only when the center has issued a notified order.
Yes.
The answer to that is that the occupation of the field operates at the stage anterior when Parliament has legislated.
No, that's the point I'm making. I'm saying Parliament can occupy the field. It's an occupiable field. Please see the schedule. Please
it's an occupied field.
No. My humble submission
implementation cannot be equated with the.
Lordship will just kindly see if my.
We will consider it, but that's a.
No, Lordship will just.
One last point on what the solicitor was saying, and then we can ask the others to argue. On at what point does the jurisdiction kick in?
Yes. No, just see the schedule for a moment.
Yes.
Now let's take, for example, take entry 27.
The last part may not be a very correct.
Anything else left on written submission? Now, Lordship, you kindly see entry 27. For example, food processing industries, canned fruits, milk foods, malted foods, flour, etc. Now, 2 points I'm going to make here. I'm saying that suppose there is no notified order with regard to milk foods or canned products. Why can't the Tamil Nadu government, or let's say Maharashtra government, make a law regarding distribution of mango, say, for example, regulate it within that state? There is no notified order. But tomorrow Parliament says that with respect to canned mango slices, this is the law. Maharashtra's power is gone. That's why I use the word occupiable field and occupied field, because there must be, that's why Tikaram says there must be a repugnancy in fact, not a de jure. It should be in fact. Otherwise, what will happen? The danger is Parliament will make a law under entry 3 and never implement it. You will paralyze the state legislatures. And if your Lordship kindly sees, there are 46 items in list 3. Technically, Parliament can make a law with respect to any of these lists and not bring it into force.
No, but food industry, it is a declared industry.
Exactly.
The Food Safety Act.
No,
FSSA, it's
no,
a declared industry.
No, I'm on a different point.
352, it is a declared industry.
Understood. Nobody disputes that. I'm answering my Lord Chief Justice's question. That is it your case that a state can make any laws with regard to these scheduled industries? My answer is yes. Say, for example, take, for example, glass, ceramics, timber, plywood. The state can regulate timber, but if there's a notified order to create timber, then I have no power. But if there's no notified order, why can't me within Tamil Nadu or Maharashtra make laws regarding movement of timber products? And the whole irony is the surprising thing is now become a center state issue. This act from 1979, there is no rule. We are arguing on a law which is not being implemented at all. The strangest irony is that after 1979, Lordship will see at the end of the footnote, there is no rule made under this act after 1979. In the 2019 Lordships of only 4 items are now regulated.
For licensing.
For licensing. This is only licensing. So what is legislatively progressing, they want to bring it back judicially in the reverse gear. With great respect, we should not do that. If Parliament has chosen, it has made the law. It has chosen not to occupy the field. It's saying the states, you please do whatever you want. We respect your autonomy. But if there's some emergency, I will step in and regulate food, soaps, timber, etc. No problem. But I am saying today that if there is no 18G order,
those industries which have been exempted today, they can always bring back the application. The exemption can be withdrawn.
We don't know what will happen tomorrow. Lord. Suppose there's some serious deforestation. Yes. Who thought of COVID? Yes. So the final point I'm making.
State will be acting under entry 33 list 3.
No. The state will be acting under entry 26 or 27. What I'm submitting is when the state is regulating, let us say, for example, Maharashtra mangoes. Suppose the state is regulating the canned fruit products or milk products in Bombay. It will be acting under entry 26, show that, 26 or 27. Trade commerce within the state, production, supply, distribution of goods. The Lordship said goods includes raw materials. Until 33 kicks in. So 26, 27 operate full vigor till a notified order kicks in under 33. That's my humble submission.
Point when what the attorney or the Solicitor General was mentioning, he said that even it's only in respect of potable alcohol, and even in the stage of ENA, that states have no power at all. He said that part you may want to respond to.
My humble submission is
the chart which he showed us at page 53.
Yes. No, I have given my chart at page 12.
Last page of your submissions.
Yeah, page 12, I've given my chart. And in this latest submission, kindly see the last page again. Again, the last page is a chart. In the latest submission, which I've where Kerala manual have shown, everything is controlled by the excise manual. Please see the last chart. All these are portable. This corner is denatured spirit. Everything is in the excise manual. It's under chapter liquor. What is happening in portable alcohol is as per the Law Commission and as per the Parliament is, once it is portable, it is exclusively state's domain. If it is non-portable, it becomes the center's domain. When does it become non-portable? When it is removed from the factory after denaturing. And that denaturing must necessarily be controlled by the states. It can't happen otherwise. Because it's for the state to decide. These are all, as your Lordship Justice Oak rightly pointed.
If your chart for a moment.
Which the latest
The chart
Kerala Excise Manual. So this is liquor.
No, the chart that you have given in your last.
1-0.
1-0.
Your latest arguments.
Yes, yes. Not except denatured spirit, ordinary special, everything else is portable. Or fit for, or it can be for human consumption. It's a red box in your Lordship's color, I think. In mine, think it's black.
So according to you, except this denatured spirit, everything is intoxicating liquor.
No, denatured spirit is actually intoxicating liquor, but it becomes unfit for human consumption. It doesn't cease to be. Lordship will kindly see.
It is also intoxicating.
Yes, because if I add methyl alcohol, I'll go blind. But if I add some other denaturant, I won't go blind. I will become sick, but I can get my kick or whatever I want to drink it.
Not used for drinking.
So the hooch strategy is only when you put methyl alcohol, because that illegal person doesn't know what is the denaturant.
The crimson color that you have put on the right.
Yes.
That is on denatured. I think it should have been put on the left side of the column.
No, I just wanted to say.
And what about rectified spirit? You say your topmost column is foreign, fermented,
yes,
and distilled.
Yes,
then distilled takes us to whiskey, brandy, rum, gin, vodka, rectified spirit.
Rectified spirit.
And rectified spirit, actually, this rectified spirit should come on top near country liquor, because rectified spirit diluted with water becomes this thing. But this is the manual which they are given. What they have said is, what are the types of liquors? What are the types? Country liquor is of two types.
No, it's not potable at all.
Which one?
It's taken your rectified spirit is not potable, Mr. Datta.
Rectified spirit is the most potable thing.
Most potable.
And what I'm submitting, why I gave this chart was
22% by volume.
Control is by the state government. Purpose was to show. Lordship will see page 12 of my chart, Lord, the first chart which I gave in my first submission, where I said rectified spirit is primary distillation. ENA is secondary distillation. Both at primary stage and ENA stage. Till 90s, it is only rectified spirit. We used to make it, there are two brands we used to sell, 26% concentration, 32% concentration with a color added to it. It was only rectified spirit diluted with, brought down from 90% to 26%. Now, because of modern technology, it become extra neutral. What do you say when you say 95% alcohol, what does it mean? If you got 1 liter of ENA, only 5% is water. 95% is alcohol by volume. So ENA now has taken the place of rectified spirit, and I'm told by the association that except Maharashtra, most of the states want to convert only ENA to a country league.
Right. We are intervening because for the create some wines association, but purely on facts. Because in common parlance, the words which are used is undenatured ethyl alcohol and denatured ethyl alcohol. Lords, undenatured ethyl alcohol is ENA, which as it is, is potable, which is used for a potable purpose. Lords, I buy around my share of IMFL produced is around 50% of the entire Indian market. My input is ENA as it is, which is coming to my factories, getting bottled and being manufactured for producing IMFL. Now, undenatured has to be treated with denaturants so as to make them denatured. Once it is made denatured, all my bottlers have common plants. Because what happens is, there's a common distillery. The common distillery will manufacture both ENA. Once that ENA is manufactured, then a denaturant is added. There is an excise officer who's sitting there. I'm paying a license fee. I'm taking a license from the state authorities. A fee is paid. Then, it is being cleared. And once it is being cleared for the paints, etc., then if it is used for industrial purposes on self-assessment basis, I'm paying a union excise duty. Otherwise, everything is under the
no GST. And Lordship, now from 1968 we got self-removal procedure. There is no officer present, but for state excise officer is present. But I clear this, and whatever goes for denatured, that goes to central excise thing. And my friend said that GST central excise, earlier central excise will be shared by the states. Now GST is centered by centers. And all these are composite plants, just to give this.
ENA
Product is
so
finally,
if you
95%
consume
is
ENA as it is, you die. It's toxic, it's poisonous. My learned friend says, Lord, it can't even be
Friend is
smelled.
going back to this beverage for human
It's
consumption.
not, Lord, that.
No, please. Lord, rectified spirit is.
Yes, therefore it is used as toxic in synthetics.
No, but today, even today under the amendment, rectified spirit is portable alcohol. ENA is portable alcohol. Under the GST, what is not portable is denatured spirit. Only when the denatured is added, it ceases to be portable. Otherwise, everything else is portable. Let us not, otherwise we'll come back to the synthetics confusion. Everything is portable. Only thing is what happens is you can't consume it fully. You have to dilute it and use it. But even for example, just to take, I was speaking to some doctors. Why do you suddenly get an intoxication? If the volume and the speed is very high, you get completely intoxicated because the liver can't metabolize it. That's why you get drunk. But if you take 30 ml and drink it over 1.5 hours, nothing will happen to you. That's the whole problem.
That's
Everything is
IMFL, not.
I'll solve. So, my lord, just to summarize, I would say, my lord, now what's happened is if my state's argument is accepted, the industry which is making alcohol, ENA, will neither be under state control nor that's the paradox. So I would only humbly submit that please restore the Balsara position. Tikaram G is good law under Article 141. I would request the Lordship to consider this theory of occupied field and occupiable field. Secondly, Mar Aprem Kuri has to be overruled. Because Mar Aprem Kuri did not consider Belsen sugar. Belsen sugar says, till you bring it into force, it is not law. It's a 5-judge bench. So Mar Aprem, apart from being per incurium, not considering a coordinate bench.
Mar Aprem is 5-judge again.
Coordinate bench should have considered it. And Lordship will just see the danger to federalism if you have the theory that just making a law eclipses the power of the states. The power of the state is eclipsed or taken away only, not only when the law is made, if that law requires a notified order or the law requires a notification or a rule, that complete process must be done. Only then occupation takes place. Deeply obliged.
Thank you, Mr. Datta.
Sorry, Lord, in case we have used a high decibel because it was.
No, between us, there are never high decibels.
Yes, sorry.
My lord, would your lordships be taking a break now, my lord, or should I start?
No,
I can finish in 10
Yes, we'll continue.
Will. My lord,
Just suggesting, what should we have? We need about 10-15 minutes. Like,
Financial implications for all the states. Huge, huge.
This
Because
attention
after
has been
synthetics, you're not
taken.
able to collect any vent fee.
At 4 o'clock, my lord.
Take a 5-minute break and come back, I think, because Tuesday. Come back in 5 minutes. We'll just take a small break, just a comfort break, and we'll come back. We'll hear you and entertain themselves until we arrive there.
But in case I'm not there I'll try to be here as much as I can.